On May 30, 2024, it's the matter of State versus Christopher Greger, case 21-1881. Court Smart's operated by our court clerk, Sue Hall. Our official court reporter is present. She is the official record. The Court Smart recording is not available for release. May I please ask counsel to place your appearances on record.
Your Honor, Christine Lento appearing on behalf of the state.
Assistant Prosecutor Jamie Sherman for the state.
Good morning, Your Honor. Mario Bellucci on behalf of Mr. Greger. Good morning, Ms. Lento. Good morning, Ms. Strong.
And Andrew Baracki on behalf of Mr. Greger. Good morning, everyone. Good morning, Your Honor.
And Mr. Greger is seated to my left, Your Honor.
Thank you, everyone. Mr. Greger again appears appropriately attired in a gray suit and tie. Courtroom 14 is available for overflow, but as of right now, we still have ample space here. Anything from counsel before we bring the jury over?
No, thank you.
And you worked out issues with the exhibits to go into the jury room?
Yes.
Judge Ferranti, I believe, and the prosecution team went through all the exhibits, put them all in a box together, and I think we're fine.
Great. All right. Ms. Grimaldi and Sergeant.
They're on their way, Your Honor.
Very good. Thank you.
We're in the building, Your Honor. All eyes.
Just give us a knock when you're ready to come out, okay? Thank you.
Yes.
You have one.
I gave it to
Yeah.
him.
Oh, you did? Okay.
I gave him like a personal.
Okay, perfect.
Yeah, I gave it to everybody.
Okay. Yes, Your Honor.
Thank you, everyone. Please be seated.
Yeah.
So just a reminder that when the jury comes out and I start my charge, then the courtroom is going to be locked. So if you're here for the duration, although I promise I won't be as long as the attorneys were in their summations. So.
We should take umbrage to that.
Well, I didn't say it in front of the jury.
About right. I thought they were.
Thank you, everyone. Please be seated. Ladies and gentlemen, any concerns or issues you need to bring to my attention? All right, seeing none, I'm going to give you the final jury charge. There are subheadings before each section, so I'll read the subheading and then read the narrative after that. We've been working like crazy with the air conditioning. Hopefully it's better. But when 12 of you are cooped up in there, the temperature's going to rise. So if it's a little chilly now, hopefully they'll be comfortable for you. They've got a contractor here. I think there was someone even in there this morning. So, but of course it's not even going to be more than low 70s out today. So you can imagine what happens when it's 90 degrees. And of course the window doesn't open either, if you've noticed that. So if at any point you're uncomfortable in there, I'm sure you'll be uncomfortable. But if it gets too uncomfortable, then you definitely need to tell us and we'll do whatever it takes. I've even considered arranging having you escorted to another courtroom that may not be in use to use that jury room. So if the air conditioning stops in there, we have a plan for that. I have to discuss with the attorneys first, but we've been trying to come up with contingencies for you, whatever we can do to try and make you comfortable or less uncomfortable. And we all appreciate your cooperation. General information. Ladies and gentlemen of the jury, the evidence has been presented and the attorneys have completed their summations. We now arrive at the time when you as jurors are to perform your final function in this case. At the outset, let me express my thanks and appreciation for your time and attention to this case. I'd also like to commend counsel for the professional manner in which they presented their respective cases and for the courtesy that they've shown to each of you. Before you retire to deliberate and reach your verdict, it's my obligation to instruct you on the principles of law applicable to this case. You shall consider my instructions in their entirety and not pick out any particular instruction and overemphasize it. Generally speaking, these instructions consist of 4 parts. The first part deals with the general principles of law that apply to a criminal case. The second part describes the evidence that you may consider in your deliberations. The third part is about those portions of the Criminal Code of New Jersey that you must apply to the facts you find in this case to determine whether the state has proven beyond a reasonable doubt that the defendant violated a specific criminal statute. Finally, the fourth part of the instructions tells you how to go about conducting your deliberations. You must accept and apply the law for this case as I give it to you in this charge. Any ideas you have about what the law is or what the law should be, or any statements by the attorneys as to what the law may be, must be disregarded by you if they are in conflict with my charge. Nature of the indictment. Now, beginning with the general principles of law that apply to a criminal case, the defendant stands before you on an indictment returned by a grand jury charging him with 2 counts, 1, endangering the welfare of a child, and 2, murder. The indictment is not evidence of the defendant's guilt on the charges. The indictment is a step in the procedure to bring the matter before the court and the jury for the jury's ultimate determination as to whether the defendant is guilty or not guilty of the charges stated in it. The defendant has pleaded not guilty to the charges. Presumption of innocence, burden of proof, reasonable doubt. The defendant on trial is presumed to be innocent, and unless each and every essential element of an offense charged is proven beyond a reasonable doubt, the defendant must be found not guilty of that charge. The burden of proving each element of a charge beyond a reasonable doubt rests upon the state, and that burden never shifts to the defendant. The defendant in a criminal case has no obligation or duty to prove his innocence or offer any proof relating to his innocence. The prosecution must prove its case by more than a mere preponderance of the evidence, yet not necessarily to an absolute certainty. The state has the burden of proving the defendant guilty beyond a reasonable doubt. Some of you may have served as jurors in civil cases, or you may have heard of the civil standard, where you were told that it is necessary to prove only that a fact is more likely true than not true. In criminal cases, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. A reasonable doubt is an honest and reasonable uncertainty in your minds about the guilt of the defendant after you have given full and impartial consideration to all of the evidence in the case. A reasonable doubt may arise from the evidence itself or from the lack of evidence. It is a doubt that a reasonable person hearing the same evidence would have. Proof beyond a reasonable doubt is proof, for example, that leaves you firmly convinced of the defendant's guilt. In this world, we know very few things with absolute certainty. In criminal cases, the law does not require proof that overcomes every possible doubt. If, based upon your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him guilty. If, on the other hand, you are not firmly convinced of the defendant's guilt, you must give the defendant the benefit of the doubt and find him not guilty. Function of the court. The function of the judge is separate and distinct from the function of the jury. It is my responsibility to determine all questions of law arising during the trial and to instruct the jury as to the law which applies in this case. You must accept the law as given to you by me and apply it to the facts as you find them to be. During the course of the trial, I was required to make certain rulings on the admissibility of evidence, either in or outside of your presence. Those rulings involved questions of law. The comments of the attorneys on these matters were not evidence. In ruling, I have decided questions of law, and whatever the ruling may have been in a particular instance, you should understand that it is not an expression or opinion by me on the merits of the case. Neither should my rulings on any other aspect of the trial be taken as favoring one side or the other. Each matter was decided on its own merits. I may have sustained an objection or objections to some questions asked by counsel, which may have contained statements of fact. The mere fact that an attorney asks a question and inserts facts or comments or opinions into that question in no way proves the existence of those facts. You will only consider such facts which, in your judgment, have been proven by the testimony of the witnesses or from the exhibits admitted into evidence by the court. Judges questioning. I don't believe I asked the witnesses any questions, but the fact that I may have asked questions of a witness in this case must not influence you in any way in your deliberations. The fact that I asked such questions does not indicate that I hold an opinion one way or the other as to the testimony given by any witness. Any remarks made by me to counsel or by counsel to me or between counsel are not evidence and should not affect or play any part in your deliberations. Function of the jury. As I instructed you when we started this case, I explained to you that you are the judges of the facts, and as judges of the facts, you are to determine the credibility of the various witnesses as well as the weight to be attached to their testimony. You and you alone are the sole and exclusive judges of the evidence, of the credibility of the witnesses, and the weight to be attached to the testimony of each witness. Regardless of what counsel said or I may have said, in recalling the evidence in this case, it is your recollection of the evidence that should guide you as judges of the facts. Arguments, statements, remarks, openings, and summations of counsel are not evidence and must not be treated as evidence. Although the attorneys may point out what they think is important in this case, you must rely solely upon your understanding and recollection of the evidence that was admitted during the trial. Whether or not the defendant has been proven guilty beyond a reasonable doubt is for you to determine based upon all of the evidence presented during the trial. Any comments by counsel are not controlling. It is your sworn duty to arrive at a just conclusion after considering all of the evidence which was presented during the course of the trial. Now I will move on to the second part of the instructions and discuss the evidence that you may consider in judging the facts of this case. When I use the term evidence, I mean the testimony of the witnesses that you have heard and seen from this witness box, any stipulations and the exhibits that have been admitted into evidence. Any exhibit that has not been admitted into evidence cannot be given to you in the jury room, even though it may have been marked for identification. Only those items admitted into evidence can be given to you. As I indicated to you yesterday, everything, every piece of paper, every tangible document is marked for identification, but only certain ones have been admitted into evidence. So, for instance, if a witness testified about something that was marked for identification, the testimony is the evidence, not the exhibit itself. Any testimony that I may have had occasion to strike is not evidence and shall not enter into your deliberations. It must be disregarded by you. This means that even though you may remember the testimony, you are not to use it in your discussions or deliberations. Further, if I gave a limiting instruction as to how to use certain evidence, that evidence must be considered by you for that purpose only. You may not consider it for any other purpose. As jurors, it is your duty to weigh the evidence calmly and without passion, prejudice, or sympathy. Any influence caused by these emotions has the potential to deprive both the state and the defendant of what you promised them, a fair and impartial trial by fair and impartial jurors. Also, speculation, conjecture, and other forms of guessing play no role in your performance of your duties. As jurors, your oath requires that you not be affected or influenced by any personal likes or dislikes, opinions, prejudices, sympathies, or biases, including implicit or unconscious bias. During your deliberations, if you think you are being affected by unconscious bias in your evaluation, think about the evidence again with the video you saw at the beginning of jury selection and with this instruction in mind. Direct and circumstantial evidence. As I instructed you at the beginning of this case, evidence may be either direct or circumstantial. Direct evidence means evidence that directly proves a fact without an inference, and which, in itself, if true, conclusively establishes that fact. On the other hand, circumstantial evidence means evidence that proves a fact from which an inference of the existence of another fact may be drawn. An inference is a deduction of fact that may logically and reasonably be drawn from another fact or group of facts established by the evidence. Whether or not inferences should be drawn is for you to decide, using your own common sense, knowledge, and everyday experience. Ask yourselves, is it probable, logical, and reasonable? It is not necessary that all facts be proven by direct evidence. They may be proven by direct evidence, circumstantial evidence, or a combination of direct evidence and circumstantial evidence. All are acceptable means of proof. In many cases, circumstantial evidence may be more certain, satisfying, and persuasive than direct evidence. However, direct and circumstantial evidence should be scrutinized and evaluated carefully. A verdict of guilty may be based upon direct evidence alone, circumstantial evidence alone, or a combination of direct evidence and circumstantial evidence, provided, of course, that it convinces you of a defendant's guilt beyond a reasonable doubt. The reverse is also true. A defendant may be found not guilty by reason of direct evidence, circumstantial evidence, a combination of the two, or a lack of evidence, if it raises in your mind a reasonable doubt as to the defendant's guilt. Credibility of the witnesses. As the judges of the facts, you are to determine the credibility of the witnesses, and in determining whether a witness is worthy of belief and therefore credible, you may take the following factors into consideration. the appearance and demeanor of the witness, the manner in which he or she may have testified, the witness's interest in the outcome of the trial, if any, his or her means of obtaining knowledge of the facts, the witness's power of discernment, meaning his or her judgment, understanding, his or her ability to reason, observe, recollect, and relate, the possible bias, if any, in favor of the side for whom the witness testified, the extent to which, if at all, each witness is either corroborated or contradicted, supported or discredited by other evidence, whether the witness testified with an intent to deceive you, the reasonableness or unreasonableness of the testimony the witness has given, whether the witness made any inconsistent or contradictory statement, and any and all other matters in the evidence which serve to support or discredit his or her testimony. Through this analysis, as the judges of the facts, you weigh the testimony of each witness and then determine the weight to give to it. Through that process, you may accept all of it, a portion of it, or none of it. Written statements of defendant. There is, for your consideration in this case, various written electronic statements allegedly made by the defendant. It is your function to determine whether or not the statements were actually made by the defendant, and if made, whether the statements or any portion of them are credible. In considering whether or not a statement is credible, you should take into consideration the circumstances and facts as to how the statement was made, as well as all other evidence in the case relating to this issue. If, after consideration of these factors, you determine that the statement was not actually made, or that the statement is not credible, then you must disregard the statement completely. If you find that the statement was made and that part or all of the statement is credible, you may give what weight you think appropriate to the portion of the statement you find to be truthful and credible. Oral statements of defendant. There is, for your consideration in this case, various oral statements allegedly made by the defendant. It is your function to determine whether or not the statements were actually made by the defendant, and if made, whether the statements or any portion of them are credible. In considering whether or not an oral statement was actually made by the defendant, and if made, whether it is credible, you should receive, weigh, and consider this evidence with caution, based upon the generally recognized risk of misunderstanding by the hearer, or the ability of the hearer to recall accurately the words used by the defendant. The specific words used and the ability to remember them are important to the correct understanding of any oral communication, because the presence or absence or change of a single word may change substantially the true meaning of even the shortest sentence. You should therefore receive, weigh, and consider such evidence with caution. In considering whether or not the statement is credible, you should take into account the circumstances and facts as to how the statement was made, as well as all other evidence in this case relating to this issue. If, after your consideration of all these factors, you determine that the statement was not actually made, or that the statement is not credible, then you must disregard the statement completely. If you find that the statement was made and that all or part of the statement is credible, you may give what weight you think appropriate to the portion of the statement you find to be truthful and credible. Redacted recorded statement of defendant. There is, for your consideration in this case, a recorded statement allegedly made by the defendant. It is your function to determine whether or not the statement was actually made, and if made, whether the statement or any portion of it is credible. You may consider all the circumstances surrounding the statement in making that determination with the following caution. I instruct you that in this case, certain portions of the recorded statement have not been provided to you. They were redacted or blacked out. You may only consider those portions of the statement which have been admitted in evidence, and must not speculate as to the contents of the omission or the reason or reasons for the omissions. Oral statements of Corey Michelow. There is, for your consideration in this case, various oral statements allegedly made by Corey to Dr. Nancy Deacon of IV Pediatrics. It is your function to determine whether or not the statements were actually made by Corey, and if made, whether the statements or any portion of them are credible. Normally, our rules of evidence would not allow statements by one witness about what another witness said. However, there are certain exceptions to that rule which allow those statements to be admissible for your consideration, but you are to give it or them the weight you deem appropriate. For instance, a statement made in good faith by a person about the person's then existing state of mind, emotion, sensation, or physical condition, including mental feeling, pain, or bodily health, can be admissible. Likewise, a statement that was made in good faith for the purpose of or is reasonably pertinent to a medical diagnosis or treatment and describes medical history, past or present symptoms or sensations, their inception or their general cause, is admissible for your consideration. In considering whether or not an oral statement was actually made by Corey, and if made, whether it or they were credible, you should receive, weigh, and consider this evidence with caution based upon the generally recognized risk of misunderstanding by the hearer, or the ability of the hearer to recall accurately the words used by Corey. The specific words used and the ability to remember them are important to a correct understanding of any oral communication, because the presence or absence or change of even a single word may substantially change the true meaning of even the shortest sentence. You should therefore receive, weigh, and consider such evidence with caution. In considering whether or not the statement or statements are credible, you should take into consideration the circumstances and facts as to how the statement or statements were made, as well as all other evidence in this case relating to the issue, including any prodding or suggestive questioning by Dr. Deacon in her questioning of Corey. If, after consideration of all these factors, you determine Corey did not make the statement or that the statement is not credible, then you must disregard the statement completely. If you find that the statement was made and that part or all of the statement is credible, you may give what weight you think appropriate to the portion of the statement you find to be truthful and credible. Defendant's election not to testify. As you know, Christopher Greger elected not to testify at trial. It is his constitutional right to remain silent. You must not consider for any purpose or in any manner in arriving at your verdict the fact that the defendant did not testify. That fact should not enter into your deliberations or discussions in any manner at any time. Christopher Greger is entitled to have the jury consider all evidence presented at trial. He is presumed innocent whether or not he chooses to testify. Multiple charges. There are two offenses charged in the indictment: endangering the welfare of a child and murder. They are separate offenses by separate counts in the indictment. In your determination of whether the state has proven the defendant guilty of the crimes charged in the indictment beyond a reasonable doubt, the defendant is entitled to have each count considered separately by the evidence which is relevant and material to that particular charge, based upon the law as I am giving it to you in this final jury charge. The state has introduced evidence which it contends supports the charge of endangering the welfare of a child as set forth in count 1 of the indictment, allegedly occurring on March 20, 2021. Included among that evidence is a video from the gym at the Atlantic Heights apartment complex. You may consider this video as evidence of the charge in count 1 and give it what weight you deem appropriate, whether that be great, slight, or none at all. However, you cannot consider evidence in support of count 1, including the video, to make your determination as to whether the state has proven the allegation in count 2, murder, except as expressly set forth in this instruction. As to count 2 of the indictment, murder, evidence of other wrongs, crimes, or acts committed on a different occasion is normally not permitted under our rules of evidence. Our rules specifically exclude evidence that a defendant has committed other crimes, wrongs, or acts when it is offered only to show that he has a disposition or tendency to do wrong and therefore must be guilty of the charged offenses. Before you can give any weight to the evidence of what allegedly occurred on March 20, 2021, you must be satisfied that the defendant committed the other crime, wrong, or act. If you are not so satisfied, you may not consider it for any purpose. However, our rules do permit evidence of other crimes, wrongs, or acts when the evidence is used for specific, narrow purposes. In this case, the state has introduced the treadmill video to demonstrate the defendant's motive, intent, or absence of mistake or accident regarding the murder of Corey, allegedly occurring on April 2, 2021. In other words, the state contends evidence of defendant's conduct on March 20, 2021, the date of the alleged endangering offense, demonstrates the defendant's motive, intent, or absence of mistake or accident on April 2, 2021, the date of the alleged murder. Whether this evidence does in fact demonstrate the defendant's motive, intent, or absence of mistake or accident regarding the alleged murder of Corey is for you to decide. You may decide that the evidence does not demonstrate the defendant's motive, intent, or absence of mistake or accident regarding the alleged murder of Corey and is not helpful to you at all. In that case, you must disregard the evidence in your consideration of count 2, murder. On the other hand, you may decide that the evidence does demonstrate defendant's motive, intent, or absence of mistake or accident regarding the alleged murder of Corey and use it only for that specific and limited purpose. However, you may not use the evidence of what occurred on March 20, 2021 to decide that the defendant has a tendency to commit crimes or that he is a bad person. That is, you may not decide that just because the defendant allegedly committed other crimes, wrongs, or acts, he must be guilty of the murder charge. I have admitted the evidence of the defendant's conduct on March 20, 2021 to be considered in connection with the murder charge only to help you decide the specific question of defendant's motive, intent, or absence of mistake or accident regarding the alleged murder of Corey. You may not consider it for any other purpose and may not find the defendant guilty of murder simply because the state has offered evidence that he allegedly committed other crimes, wrongs, or acts on a prior date. Expert testimony. As a general rule, witnesses may only testify as to facts known by them. This rule ordinarily does not permit the opinion of a witness to be received as evidence. However, an exception to this rule exists in the case of an expert witness, who may give his or her opinion as to any matter in which he or she is versed which is material to the case. In legal terminology, an expert witness is a witness who has some special knowledge, skill, experience, or training that is not possessed by the ordinary juror, and who thus may be able to provide assistance to the jury in understanding the evidence presented and in determining the facts in the case. In this case, the state and defendant have called experts to testify. The state and the defendant called Sergeant Raymond Coles, an expert in digital forensic examination and analysis. The state called Dr. Thomas Andrew, a forensic pathologist, and Dr. Anat Feingold, an infectious disease specialist. Defendant called Dr. Michael Bodden, a forensic pathologist. You are not bound by such experts' opinions, but you should consider each opinion and give it the weight to which you deem it is entitled, whether that be great or slight, or you may reject it. In examining each opinion, you may consider the reasons given for it, if any, and you may also consider the qualifications and credibility of the expert. It is always within the special function of the jury to determine whether the facts on which an answer or testimony of an expert is based actually exist. The value or weight of the opinion of the expert is dependent upon and no greater than the facts on which it is based. In other words, the probative value of the opinion will depend upon whether, from all the evidence in this case, you find that those facts are true. You may, in fact, determine from the evidence in this case that the facts which form the basis of the opinion are true, are not true, or are true in part only, and in light of such findings, you should decide what effect such determination has upon the weight to be given to the opinion of the expert. Your acceptance or rejection of the expert opinion will depend, therefore, to some extent on your findings as to the truth of the facts relied upon. The ultimate determination of whether or not the state has proven the defendant's guilt beyond a reasonable doubt is to be made only by the jury. Deleted internet history and or text messages. There has been some testimony in this case from which you may infer that the defendant deleted text messages and or internet history from his phone. The question of whether the defendant deleted anything from his phone is another question of fact for your determination. If you find that the defendant, fearing that an accusation or arrest would be made against him on the charge or charges involved in the indictment, deleted contents from his phone, then you may consider saying, in connection with all other evidence in this case, as an indication or proof of consciousness of guilt. Deleted internet history and or text messages may only be considered as evidence of consciousness of guilt if you should determine that the defendant's purpose in deleting content was to evade accusation or arrest for the offense or offenses charged in the indictment. There has been some testimony in this case from which you may infer that the defendant deleted some items from his phone. Although he is not required to do so, the defense may provide an explanation for the deletions. If you find that the deletions are not helpful to you in this case, or if you find any explanation by the defense is credible, you should not draw any inference of the defendant's consciousness of guilt from the deleted content. If, on the other hand, after consideration of all the evidence, you find that the defendant, fearing that an accusation or arrest would be made against him on a charge or charge involved in the indictment, deleted items from his phone, then you may consider same in connection with all other evidence in this case as an indication or proof of consciousness of guilt. It is for you, as judges of the facts, to decide whether or not evidence of the defendant allegedly deleting items from his phone shows a consciousness of guilt and the weight to be given to such evidence in light of all other evidence in this case. Internet searches. You have heard testimony and evidence that was admitted that a phone owned by and subscribed to by the defendant was utilized to search the internet using certain internet search terms, and that this occurred on or after April 2, 2021. The question of whether the defendant made these searches is another question of fact for your determination. If you find that the defendant, fearing that an accusation or arrest would be made against him on the charge or charges involved in the indictment, made those internet searches, then you may consider same in connection with all other evidence in this case as an indication or proof of consciousness of guilt. Internet searches may only be considered as evidence of consciousness of guilt if you determine that the defendant's purpose in making those searches was to evade accusation or arrest for the offense or offenses charged in the indictment. There has been some testimony in this case from which you may infer that the defendant made certain internet searches from his phone. Although he is not required to do so, the defense may provide an explanation as to these internet searches. If you find that the internet searches are not helpful to you, or if you find any explanation by the defendant is credible, you should not draw any inferences of the defendant's consciousness of guilt from the defendant's internet searches. If, after consideration of all the evidence, you find that the defendant, fearing an accusation or arrest would be made against him on a charge or charges involved in the indictment, made those internet searches, then you may consider same in connection with all other evidence as an indication or proof of consciousness of guilt. It is for you, as the judges of the facts, to decide whether or not the evidence of the defendant making certain internet searches shows a consciousness of guilt, and the weight to be given to such evidence in light of all the other evidence in the case. Flight. There's been some testimony in this case from which you may infer that the defendant fled shortly after the alleged commission of the crime. The defendant denies that his acts constituted flight. The question of whether the defendant fled after the commission of the crime is another question of fact for your determination. Mere departure from a place where a crime has been committed does not constitute flight. If you find that the defendant, fearing that an accusation or arrest would be made against him on the charge involved in the indictment, took refuge in flight for the purpose of evading the accusation or arrest on that charge, then you may consider such flight in connection with all other evidence in the case as an indication or proof of consciousness of guilt. Flight may be only considered as consciousness of guilt if you should determine that the defendant's purpose in leaving was to evade accusation or arrest for the offense charged in the indictment. There's been some testimony in this case from which you may infer that the defendant fled shortly after the commission of the crime. Although not required to do so, the defense may provide an explanation for these actions. If you find that the defendant's explanation is credible, you should not draw any inference of the defendant's consciousness of guilt from the defendant's departure. If, after consideration of all the evidence, you find that the defendant, fearing an accusation or arrest would be made against him on a charge involved in the indictment, took refuge in flight for the purpose of evading the accusation or arrest, then you may consider such flight, in connection with all other evidence in the case as an indication or proof of consciousness of guilt. Again, it is for you, as judges of the facts, to decide whether or not evidence of flight shows consciousness of guilt and the weight to be given to such evidence in light of all other evidence in the case. Now, I will instruct you on the third part of the instructions as to those portions of the criminal code that you must apply to the facts as you determine whether the state has proven beyond a reasonable doubt that the defendant violated a specific criminal statute or statutes. The statute read together with the indictment identifies the elements the state must prove beyond a reasonable doubt to establish the guilt of the defendant on each of the counts in the indictment. Count 1, endangering the welfare of a child, abuse, or neglect. New Jersey Statute 2C:24-4, subsection A2. Count 1 of the indictment charged the defendant, Christopher Greger, with endangering the welfare of a child. Count 1 of the indictment reads as follows. The grand jurors of the state of New Jersey, in and for the county of Ocean, upon their oaths, present that Christopher Greger, on or about March 20, 2021, in the township of Barnegat, county of Ocean, and within the jurisdiction of this court, having a legal duty for the care of, or having assumed responsibility for the care of, Corey, born May 1, 2014, knowingly did cause harm to Corey, making Corey an abused or neglected child, as defined in revised statutes 9:6-1, 9:6-3, in Public Law 1974, Chapter 119, Section 1, also known as 9:6-8.21. Contrary to the provisions of New Jersey Statute 2C:24-4A2, and against the peace of this state, the government, and dignity of the same. The statute upon which this charge is based reads in pertinent part as follows. Any person having a legal duty for the care of a child, or has assumed responsibility for the care of a child, who causes the child harm that would make the child an abused or neglected child, is guilty of a crime. To find the defendant guilty of this crime, the state must prove beyond a reasonable doubt these elements. 1, that Corey was a child. 2, that defendant knowingly caused the child harm that would make the child abused or neglected. 3, that the defendant knew that such conduct would cause the child harm that would make the child abused or neglected. 4, that the defendant had a legal duty for the care of the child or had assumed responsibility for the care of the child. The first element the state must prove beyond a reasonable doubt is that Corey was a child. A child means any person under the age of 18 years at the time of the offense. The state must only prove the age of Corey at the time of the offense beyond a reasonable doubt. It does not have to prove that the defendant knew or reasonably should have known that Corey was under the age of 18. The second element the state must prove beyond a reasonable doubt is that the defendant knowingly caused the child harm that would make the child abused or neglected. Various statutes are going to be in the jury instructions for you. New Jersey Statutes 9:6-1 and 9:6-3. Cruelty to a child shall consist in any of the following acts. A. Inflicting unnecessarily severe corporal punishment upon a child. B. Inflicting upon a child unnecessary suffering or pain, either mental or physical. C. Any willful act of omission or commission whereby unnecessary pain and suffering, whether mental or physical, is caused or permitted to be inflicted on a child. D. Or exposing a child to unnecessary hardship, fatigue, or mental or physical strains that may tend to injure the health or physical or moral well-being of such child. New Jersey Statutes 9:6-8.21 and 9:6-3. An abused or neglected child means 1. That the defendant inflicted or allowed to be inflicted upon such child physical injury by other than accidental means, which causes or creates a substantial risk of death or serious or protracted disfigurement, or protracted impairment of physical or emotional health, or protracted loss or impairment of the function of any bodily organ. 2. That the defendant created or allowed to be created a substantial or ongoing risk of physical injury to such child by other than accidental means, which would be likely to result in death or serious or protracted disfigurement or protracted loss or impairment of the function of a bodily organ. 3. A child whose physical, mental, or emotional condition has been impaired or is in imminent danger of becoming impaired as the result of the failure of the defendant to exercise a minimum degree of care in providing the child with proper supervision or guardianship, by unreasonably inflicting or allowing to be inflicted harm or a substantial risk thereof, including the infliction of excessive corporal punishment, or by any other acts of a similarly serious nature requiring the aid of the court. A person acts knowingly with respect to the nature of his conduct or the attendant circumstances if he is aware that his conduct is of that nature or that such circumstances exist, or the person is aware of a high probability of their existence. A person acts knowingly with respect to a result of the conduct if he is aware that it is practically certain that such conduct will cause such a result. Knowing with knowledge or equivalent terms have the same meaning. Knowledge is a condition of the mind. It cannot be seen. It can only be determined from inferences from defendant's conduct, words, or acts. A state of mind is rarely susceptible of direct proof, but must ordinarily be inferred from the facts. Therefore, it is not necessary that the state produce witnesses to testify that an accused said that he had a certain state of mind when he did a particular thing. It is within your power to find that such proof has been furnished beyond a reasonable doubt by inference, which may arise from the nature of his acts and conduct, and from all he said and did at the particular time and place, and from all the surrounding circumstances established by the evidence. The third element the state must prove beyond a reasonable doubt is that the defendant knew that his conduct would cause the child harm that would make the child abused or neglected. I previously defined the concept of knowing for you just a moment ago. The fourth element the state must prove beyond a reasonable doubt is that the defendant had a legal duty to care for the child or assumed a responsibility to care for the child. A person having a legal duty to care for a child or who has assumed responsibility for the care of a child includes a natural parent, adoptive parent, resource family parent, step-parent, or any other person who has assumed responsibility for the care, custody, or control of a child, or upon whom there is a legal duty for such care. A person who has assumed responsibility for the care of a child includes any person who assumes a general and ongoing responsibility for the child, and who establishes a continuing or regular supervisory or caretaker relationship with the child. A general and ongoing responsibility for the care of a child may be legal or formal, or it may arise from informal arrangements. It may be based not only upon a parental relationship or legal custody, but also on a less structured relationship, such as cohabitation with the parent of a child. A person who assumes temporary, brief, or occasional caretaking functions, such as an irregular or infrequent babysitter, would not meet the standards of general and ongoing responsibility for the care of a child. A person who supervised a child on a regular or continuing basis over extended periods of time and engages in matters that are generally committed to the child's parents would meet this standard of general and ongoing responsibility for the care of a child. In determining the nature of the relationship between the defendant and the child, you should consider these factors: the disparity in ages or maturity, the importance of the activity or activities the child supervises, the importance of the activity or activities the adult supervises to the child, the extension of the supervising relationship beyond guidance and advice expected given the adult's supervising role, and the degree of dependence and trust the child places in the adult. If the state has proven every element of the offense beyond a reasonable doubt, then you must find the defendant guilty of endangering the welfare of a child. If the state has failed to prove any of the elements beyond a reasonable doubt, then you must find the defendant not guilty. Count 2, murder and aggravated manslaughter, reckless manslaughter. So count 2 is the murder count. I've added to the jury charge aggravated manslaughter and reckless manslaughter. The fact that I have added that is not an expression of opinion by me as to whether or not you should find the defendant guilty or not guilty of those two charges. They're lesser included offenses. The decision as to not guilty or guilty is solely yours. I have no opinion, and if I did, you'd have to disregard it because you are the sole judges of the facts. New Jersey Statutes 2C:11-3A1 and 2, 2C:11-4A and B1. Count 2 of the indictment charges the defendant Christopher Greger with murder. Count 2 of the indictment reads as follows. The grand jurors of the state of New Jersey in and for the county of Ocean, upon their oaths, present that Christopher Greger, on or about April 2, 2021, in the township of Barnegat, county of Ocean, and within the jurisdiction of this court, did purposely or knowingly cause the death of, or purposely or knowingly caused serious bodily injury resulting in the death of another, specifically Corey. contrary to the provisions of New Jersey Statute 2C:11-3A, and against the peace of this state, the government, and dignity of the same. A person is guilty of murder if he, 1, caused the victim's death, or serious bodily injury that then resulted in death, and 2, the defendant did so purposely or knowingly. In order to find the defendant guilty of murder, the state is required to prove each of the following elements beyond a reasonable doubt. 1, that the defendant caused Corey's death or serious bodily injury that then resulted in Corey's death, and 2, that the defendant did so purposely and knowingly. One of the elements the state must prove beyond a reasonable doubt is the defendant acted purposely or knowingly. A person acts purposely when it is the person's conscious object to cause death or serious bodily injury resulting in death. A person acts knowingly when the person is aware that it is practically certain that his conduct will cause death or serious bodily injury resulting in death. The nature of the purpose or knowledge with which the defendant acted towards Corey is a question of fact for you, the jury, to decide. Purpose and knowledge are conditions of the mind, which cannot be seen and can only be determined by inferences from conduct, words, or acts. It is not necessary for the state to produce a witness or witnesses who could testify that the defendant stated, for example, that his purpose was to cause death or serious bodily injury resulting in death, or that he knew his conduct would cause death or serious bodily injury resulting in death. It is within your power to find that proof of purpose or knowledge has been furnished beyond a reasonable doubt by inferences which may arise from the nature of the acts and the surrounding circumstances. Such things as the place where the acts occurred, the location, the number and nature of wounds inflicted, and all that was done or said by the defendant preceding, connected with, and immediately succeeding the events leading to the death of Corey are among the circumstances to be considered. Although the state must prove the defendant acted either purposely or knowingly, the state is not required to prove a motive. If the state has proved the essential elements of the offense beyond a reasonable doubt, the defendant must be found guilty of that offense regardless of the defendant's motive or lack of motive. If the state, however, has proved a motive, you may consider that insofar as it gives meaning to other circumstances. On the other hand, you may consider the absence of motive in weighing whether or not the defendant is guilty of the crime charged. The other element the state must prove beyond a reasonable doubt is that the defendant caused Corey's death or serious bodily injury resulting in death. As I previously advised you, in order to convict the defendant of murder, the state must prove beyond a reasonable doubt that the defendant either purposely or knowingly caused the victim's death or serious bodily injury resulting in death. In that regard, serious bodily injury means bodily injury that creates a substantial risk of death. A substantial risk of death exists where it is highly probable that the injury will result in death. In order for you to find the defendant guilty of purposeful, serious bodily injury murder, the state must prove beyond a reasonable doubt that it was the defendant's conscious object to cause serious bodily injury that then resulted in the victim's death, that the defendant knew that the injury created a substantial risk of death, and that it was highly probable that death would result. In order for you to find the defendant guilty of knowing serious bodily injury murder, the state must prove beyond a reasonable doubt that the defendant was aware that it was practically certain that his conduct would cause serious bodily injury that then resulted in the victim's death, that the defendant knew that the injury created a substantial risk of death, and that it was highly probable that death would result. Causation has a special meaning under our law. To establish causation, the state must prove two elements beyond a reasonable doubt. First, that but for the defendant's conduct, Corey would not have died. Second, Corey's death must have been within the design or contemplation of the defendant. If not, it must involve the same kind of injury or harm as that designed or contemplated, and must also not be too remote, too accidental in its occurrence, or too dependent upon another's volitional act to have a just bearing on the defendant's liability or on the gravity of his offense. In other words, the state must prove beyond a reasonable doubt that Corey's death was not so unexpected or unusual that it would be unjust to find the defendant guilty of murder. Here, the state alleges Corey died of blunt impact injuries of the chest and abdomen, with laceration of the heart, left pulmonary contusion, and laceration and contusion of the liver, and the manner of death was homicide. In contrast, the defense alleges Corey died of Staphylococcus aureus pneumonia, with resulting sepsis and seizures, and the manner of death was natural. All jurors do not have to agree unanimously concerning which form of murder is present, as long as all believe that it is one form of murder or another. However, for a defendant to be guilty of murder, all jurors must agree that the defendant either purposely or knowingly caused death or serious bodily injury resulting in death of Corey. If you determine that the state has proven beyond a reasonable doubt that the defendant purposely or knowingly caused death or serious bodily injury resulting in death, you must find the defendant guilty of murder. If, on the other hand, you determine that the state has not proven beyond a reasonable doubt that the defendant acted purposely or knowingly in causing the death or serious bodily injury resulting in death, you must find the defendant not guilty of murder, and then go on to consider whether the defendant should be convicted of the crimes of aggravated manslaughter or reckless manslaughter. A person is guilty of aggravated manslaughter if he recklessly causes the death of another under circumstances manifesting extreme indifference to the value of human life. In order to find the defendant guilty of aggravated manslaughter, the state is required to prove each of the following elements beyond a reasonable doubt. 1. That the defendant caused Corey's death, and 2. That the defendant did so recklessly, and 3. That the defendant did so under circumstances manifesting extreme indifference to human life. One element the state must prove beyond a reasonable doubt is defendant acted recklessly. A person who causes another's death does so recklessly when he is aware of and consciously disregards a substantial and unjustifiable risk that death will result from his conduct. The risk must be of such a nature and degree that, considering the nature and purpose of defendant's conduct and the circumstances known to defendant, his disregard of that risk is a gross deviation from the standard of conduct that a reasonable person would follow in the same situation. In other words, you must find that the defendant was aware of and consciously disregarded the risk of causing death. If you find the defendant was aware of and disregarded the risk of causing death, you must determine whether the risk that he disregarded was substantial and unjustifiable. In doing so, you must consider the nature and purpose of defendant's conduct and the circumstances known to defendant. And you must determine whether, in light of those factors, defendant's disregard of that risk was a gross deviation from the conduct a reasonable person would have observed in defendant's situation. Another element the state must prove beyond a reasonable doubt is the defendant acted under circumstances manifesting extreme indifference to human life. The phrase, under circumstances manifesting extreme indifference to human life, does not focus on defendant's state of mind, but rather under the circumstances under which you find he acted. If, in light of all the evidence, you find that the defendant's conduct resulted in a probability as opposed to a mere possibility of death, then you may find that he acted under circumstances manifesting extreme indifference to human life. On the other hand, if you find that his conduct resulted only in a possibility of death, then you must acquit him of aggravated manslaughter and go on to consider the offense of reckless manslaughter, which I will explain to you shortly. The final element the state must prove beyond a reasonable doubt is the defendant caused Corey's death. Again, causation has a special meaning under our law. To establish causation, the state must prove two elements, each beyond a reasonable doubt. First, that but for defendant's conduct, Corey would not have died. Second, Corey's death must have been within the risk of which the defendant was aware. If not, it must involve the same kind of injury or harm as the probable result of the defendant's conduct, and must also not be too remote, too accidental in its occurrence, or too dependent upon another's volitional act. to have a just bearing on the defendant's liability or on the gravity of his conduct. In other words, the state must prove beyond a reasonable doubt that Corey's death was not so unexpected or unusual that it would be unjust to find the defendant guilty of aggravated manslaughter. Here, the state alleges Corey died of blunt impact injuries of the chest and abdomen, with laceration of the heart, left pulmonary contusion, and laceration and contusion of the liver, and the manner of death was homicide. In contrast, the defense alleges Corey died of Staphylococcus aureus pneumonia, with resulting sepsis and seizures, and the manner of death was natural. If, after consideration of all the evidence, you are convinced beyond a reasonable doubt that defendant acted recklessly, caused Corey's death under circumstances manifesting extreme indifference to human life, then your verdict must be guilty of aggravated manslaughter. If, however, after consideration of all the evidence, you are not convinced beyond a reasonable doubt that the defendant recklessly caused Corey's death under circumstances manifesting extreme indifference to human life, you must find the defendant not guilty of aggravated manslaughter, and then go on to consider whether the defendant should be convicted of reckless manslaughter. Excuse me. A defendant is guilty of reckless manslaughter if he recklessly causes the death of another person. In order for you to find the defendant guilty of reckless manslaughter, the state is required to prove each of the following elements beyond a reasonable doubt. 1, that the defendant caused Corey's death, and 2, that the defendant did so recklessly. One element the state must prove beyond a reasonable doubt is that the defendant acted recklessly. A person who causes another's death does so recklessly when he is aware of and consciously disregards a substantial and unjustifiable risk that death will result from his conduct. The risk must be of such a nature and degree that, considering the nature and purpose of defendant's conduct and the circumstances known to defendant, his disregard of that risk is a gross deviation from the standard of conduct that a reasonable person would follow in the same situation. In other words, you must find that the defendant was aware of and consciously disregarded the risk of causing death. If you find the defendant was aware of and disregarded the risk of causing death, you must determine whether that risk that he disregarded was substantial and unjustifiable. In doing so, you must consider the nature and purpose of defendant's conduct and the circumstances known to defendant, and you must determine whether, in light of those factors, defendant's disregard of that risk was a gross deviation from the conduct a reasonable person would have observed in defendant's situation. The other element the state must prove beyond a reasonable doubt is that the defendant caused Corey's death. Again, causation has a special meaning under our law. To establish causation, the state must prove 2 elements, each beyond a reasonable doubt. First, that but for the defendant's conduct, the victim would not have died. Second, Corey's death must have been within the risk of which the defendant was aware. If not, it must involve the same kind of injury or harm as the probable result of the defendant's conduct, and must also not be too remote, too accidental in its occurrence, or too dependent upon another's volitional act to have a just bearing on the defendant's liability or on the gravity of his offense. In other words, the state must prove beyond a reasonable doubt that Corey's death was not so unexpected or unusual that it would be unjust to find the defendant guilty of reckless manslaughter. Here, again, the state alleges Corey died of blunt impact injuries of the chest and abdomen, with laceration of the heart, left pulmonary contusion, and laceration and contusion of the liver, and the manner of death was homicide. In contrast, the defense alleges Corey died of Staphylococcus aureus pneumonia, with resulting sepsis and seizures, and the manner of death was natural. If, after consideration of all the evidence, you are convinced beyond a reasonable doubt that the defendant acted recklessly and caused Corey's death, then your verdict must be guilty of reckless manslaughter. If, however, after consideration of all the evidence, you are not convinced beyond a reasonable doubt that the defendant recklessly caused Corey's death, you must find the defendant not guilty of reckless manslaughter. Deliberations. I will now give you some information on the final part of these instructions regarding how to conduct your deliberations. There is nothing different in a way a jury is to consider proof in a criminal case from that in which all reasonable persons treat any questions depending upon evidence presented to them. You are expected to use your own good common sense. Consider the evidence for only those purposes for which it has been admitted, and give it a reasonable and fair construction in light of your knowledge as to how people behave. It is the quality of the evidence, not simply the number of witnesses, that control. As I said before, any exhibit that has not been marked into evidence cannot be given to you in the jury room, even though it may have been marked for identification. Only those items marked into evidence can be given to you. Very shortly, you'll go into the jury room to start your deliberations. I remind you that during your deliberations, and in fact, any time that you are in the jury deliberation room, you must not have any cell phone, pager, or other communication or electronic device with you. You are to apply the law as I have instructed you to the facts as you find them to be, for the purpose of arriving at a fair and correct verdict. The verdict must represent the considered judgment of each juror and must be unanimous as to each charge. That means all of you must agree if the defendant is guilty or not guilty on each charge. It is your duty as jurors to consult with one another and to deliberate with a view towards reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views or change your opinion if you are convinced it is erroneous, but do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You are not partisans, you are judges, judges of the facts. Unanimous verdict. You may return a verdict on each crime charged, a verdict of either not guilty or guilty. Your verdict, whatever it may be as to each crime charged, must be unanimous. Each of the 12 members of the deliberating jury must agree as to the verdict. Written copy of the instructions. As you obviously can tell, I have been reading these legal instructions to you. I'm going to give you 2 written copies of the instructions a few minutes after you get into the jury room for your use during deliberations. And you're allowed to write on them or highlight them or mark them up. Be aware that you must consider these instructions in their entirety and that I am available to assist you in understanding these instructions if you need any assistance. Also, please do not rely on the subheadings in these written instructions. They do not add anything to the explanations that I have given at great length here today, and their only purpose is to help you, me, and the parties find appropriate topics covered in these instructions. Alternates. In the next few moments, the clerk will place slips in a old-fashioned style lottery drum bearing each of your numbers. After thorough mixing, they'll be withdrawn the numbers of those who will be eliminated from the jury box, leaving only 12. Those persons eliminated will serve as alternate jurors. They'll be kept separate and under supervision of the court during the time the jury is deliberating. This is to ensure the availability of jurors should any juror then deliberating be unable to continue for whatever reason before a verdict is reached. As such, each one of those eliminated will be selected by lot, and placed within the, at such time, I meant to say. In other words, if one of you can't continue, at such time, one of those eliminated will be selected by lot and placed within the jury room, which, after being given additional appropriate instructions, will begin to deliberate again. At the present time, juror number 1 is the foreperson. If she is eliminated by lot, juror number 2 will become the foreperson. Whoever that may be, that person is charged with the duty to maintain reasonable decorum in the jury room, to give everyone an opportunity to be heard on all matters which must be discussed and evaluated, and to take whatever ballots are necessary to determine whether the jury has arrived at a unanimous verdict, and may be called upon by the clerk of the court to announce the verdict. Probably be called upon by me, actually, to announce the verdict. So all you're going to have to do as the foreperson is give us the answer of not guilty or guilty. I will read the jury verdict sheet, which I'm going to go over in a minute, and you just give us the jury's unanimous answer. I'm not going to ask you to read a whole long paragraph, so there's no reason to be alarmed. To assist you in arriving at the verdict, I prepared a verdict sheet for you. You're going to have one copy of this verdict sheet in the jury room with you, and only one. Don't write on it or make any notes on it other than your conclusions as to not guilty or guilty. The verdict form itself is not evidence. The form is to be used only by you in reporting your verdict. In order to explain it to you, I'm going to have Corporal Bennett hand out 15 copies right now We're going to go over it together, but immediately upon the end of that, you're going to turn in all 15 copies, and you're going to have one copy in the jury room. So based upon the instructions, we short one? Oh, God, good. So based upon the instructions I've given you, question 1, how do you find as to count 1, endangering the welfare of a child? The jury foreperson would check the unanimous answer of the jurors, either not guilty or guilty. You then go on to question 2, how do you find as to count 2, murder? The jury foreperson would then check the unanimous answer of the jurors as to not guilty or guilty. Only if your answer to count 2 is not guilty would you move on to question 3. If you found guilty on 2, you would stop your deliberations and you would return the verdict. But if you found not guilty on 2, you would then move on to question 3. 3. How do you find as to the charge of aggravated manslaughter? The foreperson would check the unanimous answer of not guilty or guilty. Only if you found not guilty as to 3 would you move on to 4. How do you find as to the charge of reckless manslaughter? Foreperson would check the unanimous answer of not guilty or guilty. And again, that's a court exhibit. It's marked as C14, so you're going to have the one with the exhibit tab. Madam foreperson, please keep that in a safe place. You can make notes on what you're going to have in there. Plenty of notepads, highlighters, pens, big pads, small pads. All that's your personal property. At the end of the day, if you're still deliberating on recess, I'm going to have you come back out. I'm going to instruct you to stop your deliberations. I'm going to hand the foreperson a key. You're going to put all of the evidence and all of your notes in that black metal filing cabinet. You're going to lock it up and come back out here. You're going to tell me on the record that it's locked, and the key's going to be turned over to me. I'll keep the key in a locked compartment overnight, and that way the room can be cleaned, hopefully, and the evidence won't be touched or disturbed. We're not permitted to see your notes. Your notes are confidential, so don't leave them out or anything like that. In fact, if you want to throw out some notes, I'd say just throw them in the evidence cabinet, and then after the deliberations are over and you reach a verdict, at that point, we would shred your notes. Jury's questions. If during your deliberations you have a question or feel that you need further assistance or instructions from me, or if you wish to have certain testimony read or played back, or video or audio exhibit played back, write your question or request on a sheet of paper and give it to the sheriff's officer who will be standing outside the door. Actually slide it under the door and knock. Give it that, and the officer will pick it up, who in turn will give it to me. That officer and all the officers are going to be sworn to perform certain duties, such as keeping the jury together in a private place for the purposes of deliberations and ensuring that no one speaks to you except by order of the court. You are not to discuss with or ask the officer about trial matters or procedures. And please be aware that the officer and officers have also been instructed not to communicate with you or to enter the jury room without your consent, except to communicate on my behalf regarding administrative matters, such as information about breaks or meals, or otherwise to ensure your comfort. If the officer must enter the deliberation room, the officer will knock first and complete his or her responsibilities without delay. When the officer enters the room, please stop your deliberations and do not resume until the officer has left and closed the door. If you send out a note or request, once I receive that, I'm going to go over it with the lawyers on the record, and we'll try to discuss and answer as quickly as possible. But please, I ask you to be patient, because if you're deliberating for a substantial period of time, I'm not going to make everyone just sit here. I'm going to probably tell the lawyers they can go somewhere else, work on their computers, return phone calls, and those kind of things. So it may take me some time to call everyone back here. So I've had cases in the past where there's a knock on the door, and 30 seconds later they're saying, what's going on? How come you're not coming out yet? So I'm going to work as quickly as possible, but you may be in there for as long as you like. Could be hours. So I just don't make everyone sit here. I want you to appreciate that. In addition, please do not send out if you send out a note, do not disclose where you stand on deliberations. Do not tell us, for example, that you're 10-2 or 8-4 or anything else on a given charge. If you've reached a unanimous verdict on each charge, the foreperson should write a note saying, quote, we have reached a verdict, close quote, and not what the verdict is. Knock on the door, slide it under the door, the sheriff's officer will then pick it up, advise me you've reached the verdict, and then we'll bring you back in as soon as possible. But as you know, if you haven't noticed, we've had cameras and media here, so they're going to want some time to set back up. So it may take me several minutes to get everything organized to bring you back in. A couple of issues about notes. generally speaking, notes should come from the foreperson. If you go in there, I don't want you to send me out 8 notes right away with all these questions. That's the idea of deliberations. It is your collective recollection of the evidence that controls. So to the extent you initially have questions, you should be discussing those questions with your fellow jurors. That's part of the process of deliberating. If after some time, collectively, you feel you have a question, that's when the foreperson should be writing a note. We, the jury, have a question about such and such, whatever that may be. Or we, the jury, would like to hear an instruction again. You know you have a copy of it, you may want me to read it. That sometimes happens. Or you may have some other question. So generally, individual jurors should not be writing a note to me unless it's something about you personal. You have a commitment, you have to leave by a certain time, or you have some other problem, or you're not feeling well, or something like that. So it's about 10:34. It's up to you as to breaks. So if you feel you want a lunch break, absolutely you're entitled to that. We bring you out here, I have to instruct you in the court. You must now cease your deliberations, don't discuss the case, don't do research. You can go to lunch and then come back. If you just feel like it's getting too hot in there or you're getting cooped up, you want some fresh air, just let us know that. We want to take a break for 15 minutes, go outside, go do things, whatever. We'll arrange that for you. We'll make sure sheriff's officers escort you outside so no one else comes up to you and tries to speak to you. But whatever we can do for your comfort. And then obviously, if you're deliberating in the afternoon, you reach a point, you may tell us, listen, we're done for the day. You're not obligated to stay here to a certain time. So if at 3 o'clock in the afternoon you're like, listen, we're exhausted, we want to go home and come back tomorrow, then simply tell us that. If you want to stay later, you can certainly tell us that too. So you generally should give us some guidance. So feel free to send a note saying, we're comfortable right now, we want to continue deliberating. We're uncomfortable, we need such and such. And we'll address that. Each note I mark as a court exhibit, and I go over with the attorney so they're aware of that. I've now come to the end of my charge. I'd ask to see the attorneys at sidebar. Thank you. We found one or two typos, so we're going to correct those, print it out again, and then give you 2 copies. So that's going to take a few minutes. The attorneys are going to put the evidence in a box, so the evidence is going to go in there. I think in the summations, one of the attorneys said, you can go play the video as many times as you want in the jury room. You can't do that. First, you don't have a video player, but secondly, our rules require that any playbacks of video or audio and any readbacks of testimony occur in open court. So if you do want to see the audio or visual exhibit, that would be a note you send to me, and then we play it here for you. And I don't care if you say you want to play 10 times, 25 times. You're entitled to that. So don't hesitate to say that. If you have an issue where you want to go up to close to the screen or something like that, whatever assists you. During the section on deliberations, I apparently said the word or rather than and. So I'm going to read you that paragraph again with the correct word. It is your duty as jurors to consult with one another and deliberate with a view towards reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourselves, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of reaching a verdict. You are not partisans, you are judges, judges of the facts. All right, anything else from counsel?
No, Your Honor.
All right, ladies and gentlemen, so if you go in to the jury room and help yourself, I tried to bring some things, absolutely, I tried to bring some things in for you today.
Alternates.
Yeah. Oh, we got to pick all. That's right.
Yeah.
Yes, we got to pick all. I always forget this. We have swearing officers too. But what I did is I brought extra bagels so we can take them back with the alternates over to jury assembly and give the jury assembly people some things too. So this is the part I hate the most because you've been wonderful. You've all been attentive. You've put up with our unique and challenging scheduling issues, which you really did. So, but this is a necessity. As you know, we lost one person, and it's a credit to all of you. I think the lawyers will agree with me that 15 of you have managed to start in April and we're on the verge of the end of May. So, but it's a necessary process. So I apologize in advance for it. Madam Clerk is going to spin the wheel, the drum, and we're going to pick out 3 numbers, not names.
Juror number 13. Juror number 11. Juror number 4.
All right, so again, I apologize. So respectfully, if I could ask you to come out of the jury box. If I could ask everybody to slide over in the front row. If you could have a seat in the front row. So the 3 of you can go back to jury assembly in a moment. You can have your phones. And then if there's any notes or questions, we bring you over here each time.
13.
As well as when there's a verdict, we bring you over here each time to watch. So again, I apologize, but feel free to do whatever you can do over in jury assembly. If you can take your phones and have a seat.
Your Honor, I think I might be able to use 11. Would you be okay with that?
Whatever you prefer. I mean, it's TV and jury assembly, right? So whatever you prefer.
No, this way. Oh,
You get stuff in the jury room? Well, you can go in there if you want. After, yeah, you can go in there after we're done. But
Just come sit.
yeah, just come sit for a minute. You can go in there and get your stuff because it's going to be a few minutes before you get the exhibits and
some bagels.
the typos correct and all that. Yeah, exactly.
Right here.
So you have the oath, you also. Yes. So next we're going to swear the officers in who are going to prevent anyone from disturbing you or bothering you, be there for your aid. There's going to be an officer outside that door at all times. Officers, would you please raise your right hands? Madam Clerk.
Do you solemnly swear that you will do to the best of your ability, keep every person on this jury together in a private place, and that you will not allow any person to speak to them except by order of the court?
Sergeant Dugan.
I do.
Corporal Bennett.
I do.
Officer Kennedy.
I do.
Officer Smith.
I do.
Very good. All right, ladies and gentlemen, if you could go in the jury room, and the officers want to go in the jury room briefly, get your stuff or grab a bagel. But we also have bagels going over to jury assembly. Thank you so much for your patience.
Yeah, we should
Okay.
put it in a box. That way they have something to put it into. Do we have the extra box?
Judge, do you want me to send the flash drive?
You use your phone, sir? Juror number 12?
Yes.
All right, counsel, you want any specific instruction on that, or?
Judge, state's fine with that, Judge. We don't-
I do get it, but an abundance of caution, we should probably give it.
So, juror number 12, you can clearly use your phone for the hearing aid, but you can't use your phone for any research or to look anything up, all right? You understand that instruction, sir?
Yes.
Thank you very much. Officer Bennett will get it for you.
I think we should just, that way it doesn't get lost.
The president of the jury, jury's in the jury room, alternates are on the way back.
No, thank you, Your Honor.
All right, thank you. I'm just going to correct those typos we found, and we'll get this copied and bring it out.
Thank you, Judge.
You may exit.
Want to put this first in the title? I could just
Why don't we wrap them in, like, all your little stuff? Because we didn't use any of that.
Yeah, but I don't know.
Well, that way I know where it is, like, just at least the little drives and stuff.
boxes the evidence in the case?
Yes, Your Honor.
Yes, Your Honor. Corporal Bennett, would you please provide the evidence to the jury at 10:51 a.m.? The jury and the alternates are not in the courtroom. Court's received a note from the deliberating jury, which is marked as Court Exhibit C-17 in evidence, quote, "We need to view treadmill video, please," end quote. The court's guided by certain well-settled law in New Jersey, particularly State versus Burr, 195, New Jersey 119, a 2008 case. Generally, the ability to review evidence by the jury during deliberations is subject to the court's discretion and proper instructions as to use. However, our Supreme Court in Burr indicated that video testimony or video exhibits present certain issues because playing back exhibits reveals more than a sterile readback of a transcript. A video playback enables jurors not only to recall specific testimony but also make certain credibility assessments. Video testimony is often very powerful. This case, the Burr case, deals with video testimony such as a custodial interrogation of someone, but the case expresses concerns about the dangers associated with unfettered access by a jury to video evidence. It provides a series of factors. The first is that the court should ask if a readback of a statement would suffice. That's not applicable here. This video has no audio, so there's no statements on it. If the jury persists in its request for the video, the court must take into consideration fairness to the defendant. Second, the court must then determine whether a readback of an entire portion of direct or cross-examination is necessary. Here, there really is no direct or cross-examination. Again, it's a silent video. Third, the trial judge should deny the playback if there demonstrates prejudice. And fourth, the playback, quote, "must occur in open court," close quote. Generally, the standard in New Jersey, from my understanding, is that any video evidence has to be played in open court. I'm aware, however, that prevents the jury from being able to deliberate or discuss amongst themselves things they see simultaneously with the video. In light of that, does counsel have any positions I'd like to place on the record?
No, Your Honor.
No, Judge, thank you.
All right. So if we could go get the alternates. All right, so let's bring them in, and then counsel agreed on the record that for the purposes of this, we can put the alternates back in their seats, correct?
Yes, Judge.
All right, and we'll bring the jury out. Ms. Shawn, is everything working okay?
It's working, right?
Yes? Thank you. Folks, we'll have you go back to your seats for this, okay?
Are we allowed to go up close to this one?
Sure. Have a seat, and I'll give you a couple of instructions, and we'll talk about that. Thank you, everyone. Please be seated. Ladies and gentlemen, we've agreed that the alternates can go back to their regular seats for the purpose of this so they can have a good view and be able to see everything. We have your note, quote, "We need to view treadmill video, please." That exhibit has 4 parts, A, B, C, and D. I think 2 of them, is it B and C, actually have portions of the treadmill on there. One is going in, coming in, and the other one, the last one, D, is leaving. You just want to see the aspects of the treadmill, correct?
It's just the treadmill itself.
I'd like to see all of them.
Him coming in and him leaving? Okay.
All right, counsel, any objection we play all those?
None.
During the trial, we had fast-forwarded through several minutes of just inconsequential video. So that's all we can do. That's what we did during the trial. That's all we can do now, right?
Yes.
All right, anything further about that?
No, Your Honor.
All right. One of the jurors said about going up close. Any objections if the jurors do that?
No, Judge.
All
Nope.
right, can you all do that on this TV?
Yeah.
All right, because that way, you're not being filmed over there, as opposed to if you go across the middle of the courtroom. So feel free to move about. The other issue is, though, just so you understand, everything I do has rules and case law I have to follow and those kind of things. So I think in a perfect world, somebody would say, it'd be great if you review it in there so you could discuss it.
Yeah.
I'm bound by these rules in New Jersey that says video playbacks have to occur in open court. So your deliberations have to occur in a jury room. So the best you can. You have to, right, hold your thoughts and then go in there and make some deliberations about it, if that's possible for you.
Your Honor?
Huh?
Can we ask to pause it at any time?
They want to, I know, but you still have to watch it.
How about that, counsel? Any request, if there's a request to pause it, is that possible?
I don't
No,
have
because
an
then you'll be on
objection to
camera.
that, and just leave it up to Ms. Shrano. She's the one operating.
Any objection by the state?
No, Judge.
Your Honor, I'm just
Try to
clarifying
pause
that
it.
the alternates should be viewing it as well.
Yes,
correct?
everybody should view it, right. In case we have to be replaced,
Play
in
over.
case you have to be placed into the jury, you
Yeah.
want to see whatever question the jury had. The only thing we can't do, for instance, is if it wasn't played in slow motion or in fast forward as part of the trial, we then can't slow it down for you.
Okay.
It was stopped, and it also was given still photographs, so we can stop it for you. All right, so whereupon let the record reflect, the state is playing S18. Is that it? 18?
They just shouldn't discuss it out.
They shouldn't be, I'm sorry, let me see. Judge, I have no objection to anything going on right now, but I don't think that the jury should be able to discuss amongst themselves as they're out here in public.
I just kind of tried to say
We're
that.
not going to.
They know they're not going to, so I explained. All right, so it's S18, A, B, C, and D, right?
Yes, and I'll make that reference every time I change it for the record.
Whereupon Ms.
Judge,
Strong is
can I-
going
can
to
I
play the
just-
exhibit.
Can I just stay seated when I do that and
Yes, of
interact?
course.
Okay. S18A is playing now. Hopefully. Nope. It's not playing.
Did it play before? Is it unplugged?
Everything's plugged in. It's not playing. Oh, it says it's playing. It's not. Software decoding, it's saying.
But go back out.
I sent him a message.
Oh, okay.
It's not your equipment, it's mine. It's saying software decoding on the video. Yep. Maybe I just need to not touch it for a second. Let me plug this in. This might have like the original file path. That's what Dennis was trying to explain to me. I don't really understand it, but maybe that's how that works.
okay.
Or do you use this? No, you know what? I don't need the mouse. I will figure it out. Thank you. No, I'm gonna try this way first.
This isn't even.
Yeah.
Just right click and open the deal.
Okay, hold on.
Open what?
Thank you, Andrea. Yes. Let's see.
We're good.
Here we go.
Can we pause it?
Yes, I can do it again. Sure. Yes, we did.
You want us to start again? Say for the record what you're playing.
S18B, and I'll ask Mr. Galucci if we need to fast forward any of these, what he agrees on. Okay. S18B just concluded. I'll fast forward to the appropriate part of S18C. Wrong way again. I know. Thank you. Judge, I'm going to stop S18C now.
Thank you.
Playing S18D now. I'm stopping S18D now.
Ready to move it again?
Anybody need to see me?
No? We're good then.
So it's 12:27. Do you need a lunch break, or you just want to keep going?
Oh, you guys want to break for lunch? 12:30, 12:22, or you want to go? We need to talk a little bit now.
We could talk.
So, all right, so a couple things. Right, so why don't you send us out a note saying we want to stay for X amount of time, or we want to go to lunch? And then also, if you have any other questions or anything else, you should send me out a note too. Anything else from council?
No, Your Honor.
No, thank you.
No, Judge, thank you.
Just gonna have you guys wait in the hall.
Very good, thank you.
I'm gonna restart it, so
That
it
was
should be
fine
fine.
if we start, yeah.
Right, yeah.
All right, so 12:28 p.m., the jury's back in the jury room, and the alternates are being taken out of the courtroom. Anything from council?
No, Judge, thank you.
No, Your Honor.
All right. Madam Clerk, can you hang on to those notes for me? All right, so I'll step off. I ask you to stay close so we get a note about what they want to do for lunch.
Yes, Judge, thank you.
Thank you.
All rise.
p.m. We're back on the record. The court has a note from the jury that I marked as Court Exhibit C18 in evidence. Quote, we'd like to go to lunch, please. We can go now, end quote. Give an hour, unless they ask for something different.
That's fine, Judge.
All right, very good. Sergeant Dugan's getting the alternates.
Yes, sir.
Computer and let's see if we can get started again. You know, just to see.
They're expected to see you tonight?
During lunch?
Yes.
No, you just told me that. Oh, sure. Keys.
All right, jury up.
All right.
Judge, I still have this, but can I see if it works?
Yes, thank you.
Or you want me to give it to Your Honor?
What'd you say? Can you save it, you think?
No, I still have the flash drive upstairs. I don't know if you want me to check and see if it works in case, or we'll deal with it if we need to deal with it.
Why don't we discuss it after we excuse them? Yeah, you have to sit down. Sorry. I'll explain. All right, ladies and gentlemen, I know you sent a note to go to lunch. I just have to tell you, you must stop your deliberations at this time and not recommence your deliberations until such time as you go back in the jury room. As always, please report back to jury assembly, and then we'll come and get you. So all of you can report back to jury assembly. And then any objection, if we just have the 3 alternates stay over there at that point, and just bring the 12 back to go in the jury room?
No objection, Judge.
No objection, Your Honor. Thank you.
All right, and then is an hour acceptable?
Yeah.
All right, so it's, we'll say 1:45. It's almost 12:45 by the time you get out the door. So obviously you can't discuss the case amongst yourselves when you're at lunch. But you shouldn't discuss with the alternates either. You can talk to them. You can all go to lunch together. I know one of the alternates made a request about watching the video again or something like that. So if an alternate was substituted in, there's a series of instructions I would have to give you at that point. But then you'd be part of the jury and you could make that request to your fellow jurors, and then we could do that again. But only the 12 deliberating jurors at this point can make requests. Anything else from counsel?
No, Your Honor.
No, Judge, thank you.
All right. Thanks so much. Please try and avoid any spectators or anyone like that. And same thing for any spectators. If you find yourself in the same restaurant, please try not to go close to the jurors. Don't make comments about the case or your opinions. The jury has to decide the case based upon the evidence in the courtroom only. Thank you so much.
Does anybody anything in the room?
We got it all.
And we'll keep that room locked so you don't have to lock anything up now. That's only the end of the day.
John, just grab a bottle of water out of there, cold one, please. Enjoy your lunch. Enjoy your lunch.
Anything from counsel?
No, Judge.
All right. See you
No,
in an
Judge,
hour.
thank
Thank
you.
you.
Please exit.
Chen, this is theirs.
Yeah.
Your Honor, I'm just going to put this back in the jury room.
Sure.
It's 1:51 PM. We're back on the record. All jurors are present. Court staff has gone to escort those jurors over. We're just going to bring over the 12 deliberating jurors, have them go in the jury room, and then the 3 alternates are going to stay in jury assembly.
We're on the way, Your Honor.
Very good, thank you. Just going to stop them before we go in the jury room to tell them to recommence their deliberations. They don't need to get seated in the box. Just have them go in.
Are they going straight in the back?
Yeah, I'm just going to have them pause in the courtroom for a minute and then go straight in the back.
Hold on 1 second.
That's perfect. You stay right there. That's perfect.
Okay.
All right, all 12 jurors are in the courtroom. Ladies and gentlemen, you can just put your phones down, except for juror number 12, who needs it as a hearing application device. At this time, please recommence your deliberations in accordance with the instructions previously provided. Thank you, and send us out a note of community.
I'll find out.
Okay, I'll ask.
Turning it off.
Okay. Alrighty, I'll grab it for you there.
Thank you, sorry.
No worries. This is where the microphone is.
All right, 1:56 p.m., the jury's back in the jury room, recommencing deliberation.
Thank you, Your Honor.
Thank you.
All right, now that you're all settled, you can go back out.
1 p.m., we're back on the record. We have a note from the jury which is marked as Court Exhibit C19 in evidence, quote, "We feel we'd like to hear Dr. Andrews' testimony again. Is that possible?" End quote. Counsel, we have our court reporter ready to be able to read back that testimony. Any positions from the parties?
No, Judge, thank you.
I believe the transcript excludes sidebars and any introductions, so I'm going to tell them, is it acceptable to tell them that excludes sidebar conferences and just what they heard directly?
Absolutely.
All right. The three alternates should be on the way over momentarily. As soon as they come in, we'll bring the jury out. And I would remind counsel, obviously, when the court reporter is reading back, we can't say anything because the reporter is going to be tied up reading back, not taking down any of our statements.
You're in the building, Your Honor.
Very good.
All rise.
Jury out.
Thank you, everyone. Please be seated. The 12 deliberating jurors and the three alternates are back in the courtroom. We have your note that you indicate you'd feel you'd like to hear Dr. Andrews' testimony again. Yes, that is possible. We're going to do that for you. The testimony does not include anything that happened at sidebar, so that would just be basically skipping over that in each case. So, Madam Court Reporter, Ms. Holst is going to read that back for us.
Good afternoon, everybody. This is the testimony of Dr. Andrew. This is examination by Ms. Lento. Question: Good morning, doctor. Can you tell the jurors what type of doctor you are? Answer: I'm a forensic pathologist. Question: Doctor, I am now going to show you what has been marked S049 for identification purposes. And do you recognize that? Answer: I do. Question: Can you tell the jurors what that is? Answer: This is what appears to be the most recent iteration of my curriculum vitae, my qualifications. Question: And would that aid your testimony today? Answer: Sure. Question: Now, doctor, can you tell us what your fellow is in? Answer: I did a fellowship in forensic pathology after having completed a residency in anatomical pathology in a different institution. Question: And what about your fellow in pediatrics? Answer: I went to medical school at the University of Cincinnati in Cincinnati, Ohio, and then matched in a pediatrics residency program at Cincinnati Children's Hospital Medical Center. So I am initially trained as and practiced as a pediatrician in Cincinnati prior to changing directions and going back to the University of Cincinnati to do the residency in anatomical pathology, and then a subsequent fellowship in forensic pathology. Question: And how long were you a pediatric doctor for? Answer: I started my training in 1982, and I left for my anatomical pathology training in 1988. I continued to work as a pediatric moonlighting at Children's Emergency Room and at an urgent care center in Cincinnati during the 3 years I did my anatomic pathology residency. But the last specifically pediatric work I did was in 91. Question: And where did you do your anatomic pathology residency at? Answer: That was at the University of Cincinnati College of Medicine from 88 to 91. Question: And can you tell the jurors about your fellow in forensic pathology? Answer: After I completed my training in anatomical pathology, I applied for a forensic pathology fellowship, that is a subspecialty training, with the Office of the Chief Medical Examiner in New York City. I interviewed and I got that position, and I did my fellowship there in 91, and then was invited to stay on staff as a city medical examiner for the city of New York. And I did that until early 97, and then was named acting deputy chief for Richmond County, which is one of the 5 boroughs. It's essentially Staten Island. So I was acting deputy chief for that particular borough until I left New York to assume the role of chief medical examiner for the state of New Hampshire. Question: And how long were you chief medical examiner for the state of New Hampshire? Answer: 20 years. I served from September of 97 and retired from state service in October of 2017. Question, can you tell the jurors what board certifications you hold? Answer, I am boarded by the American Board of Pediatrics in Pediatrics and the American Board of Pathology in Anatomic Pathology and Forensic Pathology. Question, can you tell the jurors about some of your academic appointments? Answer, well, when you are a chief medical examiner or affiliated with the medical examiner's office, you get some anatomic academic appointments. And you know, when I was in New York, I had an appointment at SUNY and an appointment at Bellevue. But when I went to New Hampshire, I had an appointment at Dartmouth Medical College and also did teach at the College of Pharmacy and Sciences and a physician assistant program affiliated with Franklin Pierce University. I don't have any of those positions anymore because I retired. The only academic position I currently hold is as an adjunct professor of forensic pathology for the medical school at Boston University. Question, are you currently a member of New Hampshire Child Fatality Review Committee? Answer, I'm currently not a member of that committee. However, I was there 20 years that I served as chief medical examiner. Question, have you ever testified as an expert witness in court before? Answer, yes. Question, about how many times have you testified? Answer, it is in the low 3 figures. Question, and what type of cases have you testified in? Answer, well, that my testimony has been exclusively in the area of forensic pathology. They have basically been involving issues regarding the interpretation of patterns and mechanisms of injury and cause and manner of death. These could be anything from natural deaths or accidental deaths, suicidal deaths, or homicidal deaths. Question, have you ever been published in the area of pathology or pediatrics? Answer, yes. Question, can you just give the jury some examples of those? Answer, well, most of my pediatric publications are in the area of child abuse and neglect, and sudden unexpected infant death, and the investigation of sudden unexpected death in infancy and childhood. I have other publications that are not necessarily germane to this proceeding, but other publications in various aspects of forensic pathology, gunshot wounds, drug deaths, that sort of thing. Question, and have you ever engaged in speaking engagements relating to those topics? Answer, yes. Question, and how about how many autopsies would you say have you performed during the course of your career? Answer, in the neighborhood of 6,000 or so. Question, and about how many pediatric autopsies have you performed during the course of your career? Answer, I don't log those separately, but they're probably in the range of 500 or so. Question, doctor, were you contacted by the Ocean County Prosecutor's Office in regard to the decedent Corey Michelot? Answer, yes. Question, and can you tell the jurors why you were contacted? Answer, I received initial contact from the Ocean County Prosecutor's Office in September of 2021. They asked me to review material related to the death of Corey Michelot with an eye toward rendering an opinion as to cause and manner of death. Question, now doctor, did you prepare reports in regard to your findings and opinions regarding this matter? Answer, I did. Question, if I may approach, doctor, I am now showing you what has been marked as S50, S51, and S52. Do you recognize those? Answer, I do. Question, can you tell the jurors what those are? Answer, S51. Question, are those your reports in this matter? Answer, yes. Question, and would those reports aid in your testimony today? Answer, yes. Question, now did you perform the autopsy of Corey? Answer, no. Question, can you tell the jurors who performed the autopsy? Answer, Dr. Dante Ragassa. I believe Danta is his first name. Dante Ragassa of the Ocean County Medical Examiner's Office performed the autopsy examination on Corey. Question, and when was the autopsy performed? Answer, autopsy was performed in April of 2021. Let me see what the specific date was. On the 3rd of April, 2021. Question, and did you review the autopsy report authored by Dr. Ragassa? Answer, I did. Question, and what other materials did you review to formulate the basis for your opinion? Answer, in addition to the autopsy report, I saw the images that were generated in association with the autopsy, and I examined the histological slides, and we will talk about those momentarily, the slides that you look at under the microscope. So I looked at that. And then I had medical records from 3 different hospital facilities, I believe Ocean County Medical Center, the Jersey Shore Medical Center, and South Ocean. I saw medical records from Ivy Pediatrics, which were Corey's pediatric care provider. Certainly I saw police documentation, law enforcement documentation. I saw some telephone records. I had access to the video of Corey on a treadmill. And subsequent to issuing my first report, I received additional materials. I did receive an expert report from an infectious disease specialist, Dr. Feingold, and a report from a defense pathologist expert, Dr. Bodden. Question, did you also review video from April 2nd, 2021 from the decedent's mother's phone occurring around 9 o'clock a.m.? Answer, indeed I did, yes. Question, and did you also review autopsy photos? Answer, yes. Question, do you have an opinion after you reviewed all of this material in regard to the decedent's cause of death? Answer, yes. Question, can you tell the jurors what that opinion is? Answer, I'm simply going to quote from my report, because it is a mouthful, and we will break it down. The Corey died of blunt impact injuries of the chest and abdomen with laceration of the heart, left pulmonary contusion, and laceration and contusion of the liver. Question, and can you explain to the jurors, when you say cause of death, what does that mean? Answer, cause of death is, it sounds simple enough, but it is something that's very specific. Cause of death is a disease or injury or a combination of those things that initiates what is ultimately a lethal train of events, and without which death would not have occurred. So there are many, many, many causes of death. Question, what about blunt force trauma? Can you explain to the jurors what that means? Answer, in forensic pathology, there are various kinds of external forces that can act on the body. There could be penetrating trauma, such as that from gunshot wounds or stab wounds, or there can be blunt impact injury. And in that situation, you have force applied to the body over a much broader area than, a single bullet or blade would cause. That blunt injury could be a small area or a large area, but it produces a different kind of injury than penetrating trauma does. And the kind of injuries associated with blunt force impact could include contusions or bruising of the skin or internal organs, lacerations, tears of tissue because the result of the blunt force applied to it, or fracture of bone. Question, and what affects blunt force trauma and the impact on the body? Answer, well, impact can be anything from minor to life-threatening. If you get up in the middle of the night in a strange hotel room and hit your shin against a nightstand, that may cause a contusion, raise a contusion. But all that is bleeding under the surface of the skin, and that resolves over time, and that will be fine. If you were to fall against that nightstand, you might sustain a laceration of your scalp. That may require stitches, but likewise, you would recover from that. If you sustain any of these kind of blunt impact injuries with sufficient severity, it could conceivably bring about your death, if they were severe enough. Question, after reviewing the materials in this case, did you formulate an opinion as to the decedent's manner of death? Answer, I did. Question, and can you tell the jurors what your opinion is? Answer, Corey's manner of death is homicide. While there are many, many, many causes of death, typically in forensic pathology, there are only 5 manners of death. And manner of death is simply a one-word description to describe how a death came about. And those 5 are natural, accident, suicide, homicide, or in rare instances, undetermined. In Corey's case, in that these injuries could not have been inflicted by himself with any kind of intent, it is certainly not suicide. These injuries, given their pattern and distribution, are consistent with having been inflicted by another person. Therefore, any death that is related to the action of another person is, from a medical examiner's standpoint, from an epidemiological or public health standpoint, homicide. Now, that doesn't have any legal significance, but that is the way that a medical examiner certifies it. So Corey's death was at the hands of another person, so therefore, it is a homicide. Question, does the case histology impact the determination of manner of death? Answer, well, it can in certain instances. If you have a gunshot wound to the head with a perforation of the skull and the brain, histology or examining tissue under the microscope doesn't add a whole lot. But in a case like this, certainly the examination of tissues under the microscope was helpful in reaching my conclusions. Question, did you make any findings regarding Corey's medical records from Southern Ocean Medical Center on April 2, 2021? Answer, and I'm going to ask you to clarify that a little bit because I'm not entirely certain what the question is. Question, did you review the medical records from Southern Ocean Medical Center on April 2, 2021? Answer, yes, I reviewed those records from April 2nd. Question, and can you tell the jurors if that helped to formulate your opinion as to cause and manner of death? Answer, it did, yes. Question, and can you explain why? Answer, well, Corey presented to Southern Ocean at around 3 o'clock. At that point, he was already in serious medical condition. He was ashen, gray, in a shock-like state, and was fairly medically unstable. There was an attempt to make an assessment as to what might have been going on with him by doing a CT scan, and he got worse in the CT scanner to the point where he underwent cardiac arrest. Question, and doctor, did you review any blood work from that hospital? Answer, yes. Question, and did that impact your conclusions? Answer, yes. Question, what about any post-mortem CT scans? Answer, he had a post-mortem CT scan. I don't find those of particular value, certainly compared to an autopsy, as to determining cause or manner of death. But I did see there was a post-mortem CT scan, and I looked at its result. Question, did you review the medical records from Jersey Shore Medical Center the evening of April 1st of 2021? Answer, I did. Question, and can you tell the jurors about that? Answer, well, that particular visit was at the end of a sequence of events wherein Corey initially was seen by his pediatrician, and there was some concerns about these bruises that Corey had as to whether or not this represented some mistreatment or child abuse. So Corey was referred to the emergency room, and I believe Corey and his mom went to one, but then they went to Jersey Shore after that. At that examination, he had a physical done, and they documented the various bruises that he had on different parts of his body, none of which were life-threatening. His clinical status at the time was perfectly stable. He was normal. He was conversational. He spoke with the doctor, gave a history, made some disclosures. They also did some blood work and an x-ray of his chest, and all of that was completely normal. Question, do you review the findings from Dr. Agassa's autopsy performed on April 3rd of 2021? Answer, I did. Question, can you tell the jurors what Dr. Agassa's findings were? Answer, so Dr. Agassa received, well, the body was taken to the medical examiner's office, I believe, the night before. But Dr. Agassa performed his examination on the 3rd and documented all the bruises or contusions that were on various aspects of Corey's body. Those were the primary external findings that he had, but an autopsy is a very detailed surgical examination of not only the external aspect of the body, but the internal aspect as well. There is a large, Y-shaped incision made from the shoulders to the middle of the chest, down the center of the body, allowing the pathologist to take a systemic examination of each of the organ systems. It was during that internal examination that Dr. Agassa saw and documented several abnormalities. There was a large contusion in one of Corey's lungs. I believe it was the left lung. The examination of Corey's heart externally didn't show anything, but the internal examination of the heart, after the heart was opened to reveal the chambers of the heart, a laceration or tear in the tissue was revealed near the apex or the tip of the heart on the inside wall of the heart. Below the diaphragm is that flat muscle that divides your chest organs from your abdominal organs. Below the diaphragm on the right side where the liver lives, there were 2 injuries that he documented. There was a laceration or tear in the liver tissue on the right edge, the right lateral aspect of the liver. And there was also a contusion or bleeding underneath the capsule of the liver on the front edge of the liver. There was a small amount of free blood in the floor of the pelvis, undoubtedly associated with the liver laceration. Question, now doctor, did you review slides which were prepared in conjunction with the autopsy? Answer, yes, I did. Question, and can you tell the jurors what the slides are? Answer, this was what I was referring to when I used the term histological. These are not slides like old 35mm photographic slides. This is something different. During the internal part of the examination in an autopsy, small tissue samples of areas that look normal or abnormal can be taken, and then they are processed by a laboratory such that they are cut in very, very thin slices and floated onto a glass slide. That tissue is then stained with specific kinds of stains that allow the pathologist to then see the cells under the microscope. So I did see the entire set of histological slides that Dr. Agassa had prepared in conjunction with his autopsy. Question, did you also review autopsy images? Answer, yes. Question, and can you tell the jurors specifically what image 151 depicted? Answer, image 151 was of a pulmonary contusion, meaning a blunt injury of the lung associated with bleeding. Now, there was a picture of it. It is, obviously you could see it. It's obvious that you could see it. It does not appear in his narrative description, but is depicted in the photographs. Question, and can you tell the jury about image 153? Answer, well, I have to refer to my report on that. Question, yes, doctor, if you could. Answer, 153 was a picture of the free blood that was in the pelvis. Question, can you tell the jurors about images 163 through 170, please? Answer, those were various views from different angles of the liver injuries. Question, what about images 172 through 178? Answer, those depicted injuries in different parts of the body. 172 to 75 were hemorrhage in the retroperitoneal tissue. Sorry about the jargon, but I mean that's where it was. What is that? The abdomen is lined by a lining called the peritoneum. Retroperitoneum means bleeding underneath the peritoneum. This was towards the back of, where the backbone is. 76 to 78 was similarly hemorrhage, contusion, and it was in the area of his left shin, ninth rib. I'm sorry, in the area of his left ninth rib. That may well be what was associated, that trauma on that side may well be what was associated with the contusion of the lung itself on that side. And then, so yes, that takes us to 178. Question, okay, doctor, and did you review images 196 through 200? Answer, yes. Question, and can you tell us about those? Answer, these images were, I should preface this, I explained when I was talking about when an autopsy is approached in general, I do that incision in the front. In cases where it is important to do, the death of somebody in police custody, for example, or in this case, a potential child abuse case, you do a similar examination of the back. So you turn the body over, and an incision is made along the midline of the back, and that skin is reflected so that you can see the muscles of the back. These images, 196 to 200, depicted soft tissue hemorrhage or contusions along the spine or the backbone that you could not see necessarily on the surface of the skin. There were certainly contusions on Corey's back, but there were also contusions that did not correlate with deep contusions that didn't correlate with contusions that were on the skin. Question, can you tell the jurors about the myocardial laceration depicted in image 0205? Answer, yes, and this is complicated. So you all remember from high school biology, right? The heart has these 4 chambers, the 2 upper chambers and the 2 lower chambers. On looking at Corey's heart from the outside, all that could be seen was an epicardial contusion on the front of the heart. The epicardium is just the lining of the outside of the heart. So he had a visible contusion on the outside of the heart. But it wasn't until the heart was opened in such a way that you could see the inside, each of the chambers, that this laceration was revealed. On the left ventricle, which is the lower left chamber of the heart, that is the muscle 1. That is the one that pumps the blood out to the rest of the body. And there were tissues, tear in the tissue. Dr. Ragasa described it as about 1.5 inches, and that comports with the photograph, a horizontally oriented tear near the tip of the apex of the heart into the muscle. It didn't go all the way through the heart wall. It was just a tear of the heart muscle in the internal surface of the left ventricle. Question, doctor, did you review images 206 to 220? Answer, I did. Question, and can you tell the jurors about that? Answer, this was a series of images of scalp contusions. Corey didn't have a lot to see externally on the scalp. There was maybe one abrasion or contusion near the eyebrow, but when one looked at the skin or underneath the skin, there was a contusion on the top of his head and a couple of contusions on the back side of his scalp that you couldn't see on the surface. Question, doctor, did you make any findings regarding bruising on the decedent's body which was significant in regard to your formulation of your opinion? Answer, well, in assessing the potential for child abuse, it is not so much that contusions are life-threatening in and of themselves, but it is the pattern and distribution of injuries and also the presence of injuries of varying ages that suggest a child has been mistreated. And Corey had contusions over a wide area of his body of varying ages from under his chin, his head, his trunk, his extremities. There was one fairly large one just on the left side of his chest that looked to be very large, and that had been previously assessed. And particularly the presence of contusions on the back without a pretty clear-cut explanation is not diagnostic of abuse, but it's very suggestive of abuse, certainly given the company that it's keeping. So my concern was not so much with the severity of the bruising, but the pattern and distribution of bruising as being suggestive of child abuse. Question, doctor, did you make any findings regarding the decedent's liver? Answer, yes. Question, and can you tell the jury? Answer, well, as I said, there were 2 injuries. Question, Answer, one of them fairly minor. It was on the front edge of the liver, and it was just a contusion. That is not particularly uncommon after CPR, but there was a second, more significant injury, and that was out on the right side, the right lateral edge of the liver. It was described as a superficial contusion, but the photos clearly show that it was a contusion that goes fairly deeply into the liver tissue itself. And under the microscope, this was not a super fresh injury, so this was not an injury that could be attributed to CPR. So those are the two findings involving the liver. Question, doctor, were you able to formulate an opinion as to the time frames when these blunt force trauma injuries were inflicted? Answer, only in a general sense, giving a range of time. To dispense with the contusions first, many of them were sampled under the microscope, and many of them were pretty much all healed or mostly healed. You could see something on the surface of the skin, but not much going on underneath it. So other than to say on my gross inspection of these bruises they appeared to be of varying age, that is as far as my opinion would go in regarding bruising. The internal injuries, on the other hand, have a little more objective evidence to offer in terms of timing. And the basis for that is something called the inflammatory process. So what does that mean? When tissue is injured, there is a fairly predictable sequence of events that occurs in the body's attempt to repair itself. That is what inflammation is, or one type of inflammation. So that inflammatory process involves the appearance of certain kinds of repair cells to the area of injury within a fairly predictable time frame. So I examined both and I did not generate new slides. These were slides that were done at the time of the original autopsy. So slides of injury and slides of the heart injury and slides of the liver injury. And in both of these injuries, there was a fairly well-established acute inflammatory process there. The cells that make up the acute response are called, I've got to say it because they have a name, they are called polymorphonuclear leukocytes. Wow. Let's just call them polys. So polys are recruited to the scene within hours after an injury like this. The second wave of inflammatory cells are called mononuclear cells. Those are pretty rare. I only saw those here and there. After that, and those, take up to like 24 hours to get there. And then after 24 hours, you actually start to see some attempt to heal the tissues. Fibrins laid down, and you see other cells called fibroblasts. Those weren't present. All I was seeing was this acute inflammatory process that was fairly well established, and that was in both the heart and the liver. So what does that mean? Well, that means that, in my opinion, these injuries occurred at roughly the same time, and their age could have been as recent as 4 hours, but as old as 12 hours, prior to when Corey actually died at 5:00 p.m. on the 2nd. That was the finding based on the histology. Additional evidence that I saw fine-tuned that time frame a little tighter. Question, and doctor, can you tell us about the additional evidence that you saw to fine-tune that time frame? Answer, so if you think about that time frame of 4 to 12 hours, that would have been from 5:00 a.m. the day before to 1 o'clock in the afternoon on the 2nd. There was a video that was alluded to, and it wasn't an intentional video. There were no people in the video. You could basically see that the phone was on a car seat or something, and there was some colloquy in there. A question. Doctor, can you explain to the jury if there was an opinion or determination or findings that you made after review of the materials regarding blunt force trauma and the CPR post-mortem? Answer, yes. I was specifically asked questions about that because I believe these were questions that were raised in the original autopsy report. In my opinion, given the age of these injuries, it is entirely incompatible with them having been produced by CPR because they wouldn't have had this inflammatory response that takes hours to develop. Furthermore, I don't know anybody who does CPR on the right side of the chest. CPR is done on the front of the chest. And like I said, the anterior liver injuries are not commonly seen with CPR, but not an injury out on the side of the liver that goes deep into the tissue. And thirdly, I've seen a lot of CPR injuries, more in adults than kids. Adults they have a lot of CPR injuries because our ribs fracture much more easily. I have seen a fair number of CPR-related injuries in pediatrics. I've never seen an endocardial or an internal laceration of the heart like this one. So in my mind, I'm quite confident that these injuries are not CPR-related. Question, so doctor, were you able to determine that the injuries occurred while Corey was still alive because of the inflammation? Answer, oh, exactly, yes. Question, did you make any findings regarding sepsis or infection? Answer, once again, that issue came up on initial examination. And based not only on the autopsy findings, but my review of the medical records, there is zero, not one scintilla of evidence of sepsis or any other infectious process in Corey's autopsy. Question, doctor, did you note any findings regarding stress cardiomyopathy regarding the decedent's heart? Answer, I did. Question, and can you tell the jurors what stress cardiomyopathy is? Answer, cardiomyopathy. So cardio refers to the heart, myo is muscle, and pathy is pathology. So this is some sort of abnormality of heart muscle. As the name suggests, stress cardiomyopathy is an abnormality of the heart muscle that's produced by chronic ongoing stress. It is not visible to the naked eye. It is seen under the microscope. There are well-described changes of individual heart muscle, changes in the color, changes in the way that the innards of each cell looks under the microscope, changes in the way that the nucleus, the nerve center of each cell looks. These findings were pretty widespread in areas of Corey's heart. Some of the findings that are associated with what has been called stress cardiomyopathy, which is in the literature, are associated with CPR because the heart is dying at that point. And some of these findings can be seen also in CPR, but the constellation of all of these findings and the distribution of them throughout the heart says to me that this is not related to CPR, but it is related to chronic ongoing stress. So while Corey's immediate cause of death was the blunt impact injuries that he sustained the day he died, the presence of stress cardiomyopathy suggests that there was ongoing physiological stress, most likely due to the ongoing mistreatment or abuse. Let's see. And there was a recess at this point. Okay. Back with Ms. Lento questioning. Question, so we may turn to what's marked as S97, please, already in evidence. Doctor, we now have up on the screen S97. Can you please tell the jurors what that is? Answer, that is a very small contusion. It looks like an abraded contusion, sort of a combination injury on Corey's forehead. Question, and is S97 a picture? Is S97 a photograph? Answer, yes. It is a digital image that was generated in conjunction with the autopsy. Question, okay. And can you just explain again what is depicted in S97 in the photograph? Answer, okay. Your Honor, may I stand? And then comes down to with the pointer. Okay. So it looks like we are looking at the left side of Corey's head. You can see his hairline is here. This is just the outer edge of his eyebrow on the left side there, and that is Dr. Regas's thumb for a measuring device. So you can see a small abraded contusion that measures, no more than a half an inch, maybe 3/8 to a half an inch. Question, can we go to the next picture, please? And can you tell the jurors what S98, that photograph, depicts? Answer, a contusion behind the ear it really requires some sort of an explanation. That's an injury that at least raises, it's not a diagnostic, but it raises the question of mistreatment of a child. Question, and why would that raise that? Answer, well, because it is a protected area. It's not normally injured in a slip and fall. Now, if you fall against something, that it could conceivably, press your ear hard enough against that bony part, the mastoid process there. But most of the time, at least in my experience, it is generally associated with other injuries that suggest mistreatment. Question, can we go to the next picture? Can you tell the jurors what is depicted in S99, the photograph? Answer, just to orient you as to where we are anatomically, this is Corey's left shoulder, all right? The left side of his neck, left ear. So there is this linear contusion. It's a brownish, yellowish contusion up under his chin. You can also see this is pretty regular. I suspect this was some sort of EKG monitor pad. So that is not an injury. See how regular that is? It has a hole in it. So this main thing here is the contusion under his chin. Question, and what is significant about that? Answer, well, the significance of a contusion under the chin in and of itself is very little. But in the context of examining a child who has multiple injuries of varying ages in different parts of the body, particularly from under the chin and around the neck area, once again raises the question of whether or not that child has been mistreated. Question, can we please go to the next photograph? Doctor, I'm calling your attention to what has been marked into evidence as S101. Can you please explain what has been depicted in that photograph to the jury? Answer, in S101, Corey has been rolled up onto his right shoulder. This is Corey's left ear. So that is his head. Right shoulder, left shoulder. What is being emphasized in this image are two contusions. Now, in and of themselves, it's a little distal of a contusion, a dangerous thing? No. But a contusion over the shoulder blade and sort of directly over the spine in a child without some sort of history of how that came about is not an area that you typically see injured in the run and play and slip and fall of a child. It is the context, it is the pattern and distribution that makes it an important one. Question, can we move to the next photograph, please? This is S100. Can you tell the jury what that depicts? Answer, so Corey is laying once again on his side, and we are looking at his hip area. So the buttocks would be down here, the back would be up here, and we are looking at a fairly broad abrasion. And we've talked a lot about contusions, but abrasions are a different kind of a blunt impact injury. If force is applied sort of tangentially or, sweeping across the skin, it can raise the superficial layers of the skin up. Raspberry, right? And that is the kind of injury that we are seeing here. This is an abrasion, a rather large confluent abrasion over his hip. Again, the context is what makes it important. That is not a lethal injury. It's not a life-threatening injury. But in the context of everything else that we are seeing, it is a significant injury. Question, can we please move to the next photograph? S60, doctor, can you tell us what that depicts? Answer, this depicts a contusion or a bruise that captured a lot of people's attention. So this is Corey's right shoulder, armpit area. There is the right nipple. There is the left. Just above it, there is this vaguely patterned contusion that is partially healed. It is fairly large, and it is in a very odd place. Unless there is a good explanation for it, it was evaluated by several care providers. Question, can we move to the next photograph, please? Now we have S59, a photograph. Can you tell the jurors what that is a photograph of? Answer, this is an internal photograph from the autopsy, the internal aspect of the autopsy. And it is a picture of the liver. And it is specific, the outer right side, that lateral edge of the liver. So on the surface of the liver, what you see is this. There is this little bit of bleeding, and then you can see the tissue that was torn. But Dr. Ragasa made an incision right in the middle of this injury to see what was underneath it. And you can see that all of this is abnormal. It should be uniformly this color. What you are seeing here is a fracturing or disruption or laceration of the liver tissue that comes when the liver tissue is compressed in some way. And as I said, CPR is performed in the front. It is not performed out here on the side. Question, doctor, is that a significant injury? Answer, it's not a life-threatening injury. As ugly as it is not a life-threatening injury. Had Corey presented with this and nothing else, they would have probably seen it on the CT scanner and maybe put him in the hospital and observed him to make sure that he did not have ongoing blood loss, and then discharged him to let him, with some physical restrictions, to let it heal on its own. So it's nasty, but it's not life-threatening. Question, can we move on to the next photo? Doctor, can you tell us what is depicted in S58, please? Answer, this is likewise another internal photograph from the autopsy. In this instance, you are looking at the heart. That doesn't look like any kind of a heart that you have ever seen before because it's been opened. So the heart has been opened to reveal the inner side or the inner surface of the left ventricle, the left lower chamber. What is seen here is an actual tear in the tissue. This wall should be continuous, and there is a tear on the internal surface of the heart near the septum. The septum is that muscular wall that divides the left from the right side. So it's got a partial thickness tear of the heart on the left, the inside left ventricle. Question, now doctor, can you tell the jurors about the severity of the tear and the relation to thickness? Answer, this is a severe injury. This is an injury that triggered Corey's death. Why? Well, he didn't bleed to death. This laceration didn't go all the way through the heart muscle. It is not a hole in the heart. It is not a tear that goes through the heart. In that case, there would have been an enormous amount of blood loss very quickly, and he would have never survived as long as he did. In this instance, in that it was a partial thickness, his heart could at least for some hours compensate for this injury. But I had mentioned the septum. The septum is where these specialized heart cells that control the rhythm of the heart live. So you've got these natural pacemakers on the upper part of the heart, and then they divide into specialized fibers that go down the septum. Disruption of this can trigger rhythm disturbances, arrhythmias of the heart. That's likely what happened to Corey in the CT scanner, why he went into cardiac arrest. With CPR, they weren't able to restore some sort of normal rhythm, but they were able to restore some sort of normal rhythm, but couldn't maintain it. He kept going into, I believe it was a rhythm called ventricular tachycardia, and they ultimately could not resuscitate him from that. So that is how that injury mediates his death. It's not, trauma, bleeding, exsanguination. This is trauma. The heart tries to compensate. The heart eventually decompensates, and he sustains a cardiac arrest due to his trauma. Question, now doctor, are you able to review the inflammation which you spoke about before in that photograph? Answer, no. The inflammatory process is something that you see under the microscope. So Dr. Ragasa took samples, well, from the other areas of heart as well, but from and in around this tear, and that is why I saw the inflammation that allowed me to draw an opinion or come to an opinion as to the age of that injury. Question, okay, could we go to the next photo, please? Doctor, I'm now showing you, or it is up in the courtroom, what has been marked into evidence, S152B. Can you tell the jurors what that is? Answer, I received this image subsequent to my initial report, but I received it in conjunction with this question about timing. We already talked about the video at 9 o'clock. It has been represented to me, and I believe there has been some sort of analysis of the photo that indicates it was taken, you know, on or about 2 o'clock in the afternoon. To me, I don't know, Corey could be sleeping, but it's certainly not inconsistent at all with him already having sustained what were ultimately his fatal injuries. And he presents an hour later to the emergency room looking not much different than that, save for the fact that his vital signs were unstable and his color was ashen. Question, so doctor, would that photograph be consistent with your opinion regarding the timing of the blunt force trauma injury? Answer, yes. Question, can we move to the next photo, please? Oh, I think we are done. Okay. If you could go back to the witness stand. Now, doctor, in conclusion, based upon everything that you have reviewed, what is your medical opinion regarding the cause and manner of death of Corey? Answer, Corey Michelot died of blunt impact injury of the chest with laceration of the heart, contusion of the left lung, and laceration and contusion of the liver. It is a traumatic cause. The manner of death is homicide. It was at the hands of another person. He didn't do it himself, and it didn't happen accidentally. And now we're going to do the cross-examination by Mr. Gallucci. Question, how are you, doctor? Answer, good to see you. Question, good to see you too. Have you ever been to Hanover? Have you been to Hanover lately? Answer, I haven't been to Hanover fairly recently. Question, all right, let's get to it. Answer, yes, sir. Question, did you review all the police reports in this case? Answer, I believe I reviewed police records. I cannot say for certain that I saw every single police report. Question, do you recall? Answer, I saw some. Question, I'm sorry, I didn't mean to interrupt you. Answer, I saw some. Question, did you review Detective Mitchell's 29-page synopsis of the case? Answer, I did. Question, okay. Did you review the records from Dr. Harry Larkin? Answer, that name is not familiar to me. Question, okay. Did you review the records from Southern Ocean Medical Center? Answer, yes, sir. Question, did you see any records in there from Dr. Larkin? Answer, I don't. That name, I don't look for names, so I can't recognize the specific name. Question, did you review Dr. Ragasa's medical examiner report? Answer, I did. Question, did you review his findings? Answer, I did. Question, did you review the Community Medical Center report? Answer, yes, sir. Question, and did you review Jersey Shore Medical's medical report? Answer, I did. Question, did you review Southern Ocean Medical Center's report? Answer, yes. Question, did you review the grand jury minutes in the case? Answer, grand jury minutes? I'm going to refer to my report. Answer, yes. Answer, I don't see it listed on my initial report or any of my supplemental reports. Question, okay, so you were hired by the Ocean County Prosecutor's Office sometime in September of 2021, right? Answer, correct. Question, okay, and do you recall if that was prior to the medical examiner issuing his report? Answer, no, I believe it was after. Question, okay, so are you still an ME in New Hampshire? Answer, I retired from state service in 2017. I maintain a consulting practice, and that is the role that I am playing here today. Question, prior to reviewing the file and agreeing to become an expert, or maybe after you agreed to become an expert, did you have an opportunity to speak to Ms. Lento? Answer, yes. Question, did you have an opportunity to speak to Ms. Schroen? Answer, we communicated primarily via email. My primary discussions were either with Detective Mitchell or Attorney Lento. Question, so did you speak with Detective Mitchell also? Answer, I did. Question, okay, and what was the first time you spoke with Ms. Lento? Answer, I don't recall specifically. I received the initial material for review, and we very likely had a conversation via telephone sometime between my receiving the material in late September and the issuance of my first report in February. So we undoubtedly talked one or more times in that interim. Question, and did you also, you said you spoke to Detective Mitchell, right? Answer, yes. Question, okay. Do you remember when you spoke to Detective Mitchell? Answer, no. Those were primarily conversations regarding transmittal of documents, timing, and scheduling of conferences with Attorney Lento. Question, so when you spoke with Detective Mitchell, and you've already testified that you read this 29-page report, did you notice anything in there about one of the medical examiners from Ocean County Medical, Ocean County, from Dr. Harry Larkin? Answer, this is starting to ring some bells. Question, okay. Answer, I believe Dr. Harry Larkin might have been the initial responder from the Ocean County Medical Examiner's Office, and please correct me if I'm wrong. Question, I will. Answer, no doubt. I believe he is the one who ordered the post-mortem CT scan on the body of Corey Michelot. Question now and he's a medical examiner from Ocean County, right? If you know. Answer, that is his title. I don't know what his credentials are, but that is his title. Question, and you are a medical examiner, right? Answer, yes, sir. Question, and a medical examiner is the one that actually physically does the work that you just testified about? Answer, as far as autopsy goes, yes. Question, right. So when you were a medical examiner, you were the one that did the slides, right? Answer, I obtained the specimens. The laboratory generated the slides. Question, and you are the one that would open up the body? Answer, yes, sir. Question, and you are the one that would remove the organs? Answer, yes. Question, you are the one that, as we saw, the liver was opened up, right? You are the one that would do that? Answer, yes, sir. Question, and would you also take those pictures or somebody else would take the pictures? Answer, depends on the agency. In New Hampshire, I take my own pictures. Question, so Dr. Larkin ordered a CAT scan after Corey had passed, right? Answer, yes, sir, yes, sir. Question, now, that is very unusual, right, for a medical examiner to order a CAT scan after someone has passed? Answer, again, that depends on the jurisdiction. Some offices, they are really, like Baltimore, they are very well endowed. They have a CT scanner in their office. So for them, it is not unusual. I don't know what the standard is in Ocean County. I certainly don't routinely or did not routinely do it in New Hampshire. So in New Hampshire, unusual. Baltimore, another day at the office, and everything in between. Question, so it was unusual then for Dr. Larkin to order a CAT scan in New Jersey? Answer, I don't know what the standard is here. I don't know how often it is done. Question, but he also ordered blood work at that time, right? Answer, that I don't recall. I recall the CT scan, and he certainly would have had access to the blood work that was already done in conjunction with the resuscitation effort. But I am not aware of any additional lab work he ordered. Question, are you aware of the blood work that was taken from the decedent after he had passed? Answer, the only thing I'm aware of that was taken post-mortem was the toxicology specimens that were taken in conjunction with the autopsy by Dr. Ragassa. Question, how about the blood work taken before he was deceased? Answer, that would have been blood work taken by the Southern Ocean. Is it Southern Ocean? Question, is Southern Ocean Medical Center. Answer, during the resuscitation effort. Question, and are you aware that in that blood work there was a high white blood count, high glucose level, and high lactic acid? Answer, yes. Question, that Dr. Larkin found that was indicative of sepsis and infection? Then we had a sidebar. Question, hi doc. Question, do you recall what Dr. Larkin's position was with the Ocean County Medical Examiner? Answer, I just knew that he had the title of medical examiner. I don't know his credentials or nor would know what his specific role was. Question, now you reviewed a number of reports in order to come up with your conclusion. Am I right? Answer, yes. Question, one of the reports you just testified that you reviewed was Detective Mitchell's investigation report. Answer, yes. Question, did you rely somewhat on the report to make some of the conclusions you have here? Answer, in terms of timelines and that sort of thing, yes. Question, okay, so did you ever you never went to Southern Ocean Medical Center, right? Answer, correct. Question, you never saw Corey, right? Answer, not physically, no. Question, you never ordered any of your own tests, right? Answer, no. Question, you never ordered any of your own CAT scans, right? Answer, no. Question, you just reviewed results of other people? Answer, yes. Question, and you relied on whatever they did to make your decision? Answer, that's fair. Question, and so you did read the report for Southern Ocean Medical Center's CAT scan. Do you know what the result of that was? Answer, yes. Question, okay. And the result of that was that there was an indication for extensive airspace disease in his upper lungs consistent with lung disease. You did read that, right? Answer, I read that, yes. Question, okay. And you also read the x-rays. Did you see the x-ray reports from Southern Ocean Medical Center? Answer, I remember the x-rays from Jersey, but I can't remember the specific wording of the x-ray reports from Southern Ocean. Question, okay, so let's use Jersey Shore then. At Jersey Shore, you are aware that they yielded negative results for any injury? Answer, yes. Question, okay, and did you review or go through any of Dr. Danta Ragassa's reports? Answer, yes. Question, okay, so Dr. Ragassa is actually the medical examiner in Ocean County, or one of them, I guess. Answer, one of them, certainly. He is the one who did the autopsy, the original autopsy on Corey. Question, so he's the one that did everything. He is the one that took Corey. He is the one that did the whole entire autopsy? Answer, yes. Question, okay. Now, he reported on a number of injuries, just like you discussed, and he said that they were due to life-saving techniques. Answer, yes. Question, okay. And are you disagreeing with that? Answer, yes. Question, now, you are also disagreeing with the results of the CAT scan showing disease, lung disease? Answer, I am not disagreeing with what the CAT scan shows. CAT scan shows what the CAT scan shows. My disagreement is in the interpretation of that CAT scan. This is a post-mortem CAT scan read by a clinical radiologist. Post-mortem CT scanning is occasionally used, but it takes special training to interpret the results of those post-mortem CTs because they don't look the same in dead people as they do in living people. For example, the appearance of lung disease is simply a manifestation of blood no longer flowing through the lungs. Whatever blood is in there is there. It's not moving. So if the blood is contrasted with air, so it looks like airspace disease. Furthermore, Corey had a well-demonstrated confluent contusion of his, I believe it was the left lower lobe. Now the CT scan describes the upper lobe stuff. But a contusion on a CT scan, these are lights and shadows. This isn't having it in your hand. A contusion on a CT scan would look like pneumonia. So my disagreement is not in what it shows. My disagreement is in what it means. Question, so do you disagree with Dr. Ragasa? Answer, in regard to question, life-saving. Answer, yes, sir. These are not CPR injuries. Question, so now that is a contrarian view. You would agree with me, you are contrary to what the medical examiner here in Ocean County said? Answer, no, I don't think it's a contrarian view. It is a second opinion. And as a matter of fact, it was reviewed not only by Dr. Ragasa's supervisor, Dr. Falzone, the chief medical examiner for the state, but taken before a child fatality review committee. Dr. Ragasa subsequently changed his report to reflect that this was a homicide. Question, and wasn't that after your report? Answer, yes. Question, okay. So the Ocean County medical examiner changed their report after you gave them your report? Answer, that's my understanding. Yes, sir. Question, so do you recall a case that I believe you were the medical examiner on called Patrick McCarthy? Answer, yes. Question, Patrick McCarthy, I believe, was a 10-year-old child? Answer, yes, he was. Question, in that case, you were, in fact, the medical examiner? Answer, yes. Question, so were you the actual one that did all the physical work? Answer, yes, sir. Question, okay, and in that case, you said as the medical examiner it was not a murder? Answer, I did. Question, okay, 6 experts, including Dr. Bodden and the FBI, said it was a murder? Answer, no, I don't believe that's true. There were experts that said it was homicide. Likewise, there were a number of experts who agreed with me. And it was my understanding that the FBI, say for one agent who was very, very, let's say, emotionally connected to the case, was insistent that it was a homicide. New Hampshire Fish and Game, New Hampshire Crime Scene Unit, New Hampshire Department of Justice, and the prosecutor, the federal prosecutor in New Hampshire, all agreed that indeed Patrick had died of hypothermia. Now, there is disagreement. I never changed my determination based on what the others said because I did not find it credible. Nevertheless, the family has indeed for, I think it might be 20 years now, has established a website that portrays me as Satan incarnate because I am, quote, covering up a homicide. So yes, I don't think I will ever forget that case. Question now, you kept using a word on direct exam where you would say not of diagnostic value. What does that mean? Answer, I think I was using that phrase in the context of some of these contusions, like taken individually, one contusion is not diagnostic of child abuse. Multiple contusions varying stages of healing distributed over a suspicious area on the body is far more suggestive of inflicted injury than an individual bruise, which is not diagnostic. Question, so are you saying that if Corey was struck on the right hip by a blunt force that it would cause the laceration you see in the heart? Answer, no. Question, okay, are you saying that the injury to the chest, by the way, how old, if you know, how old was that injury to the chest? Answer, which injury? Question, the one that is not the one that was due to the hospital, the one in the middle of his chest. Answer, oh, the bruise? Question, yes. Answer, I don't know. Question, can you age bruising? Answer, to some extent. It is not nearly as reliable as inflammation internally. There are some criteria to use for aging bruising, but it is not as reliable. Question, so if that bruise was caused 12 days prior by the treadmill, and between the treadmill we know that he played football, he went to football practice, he was in his mother's care, he was in his father's care, he was in his grandparents' care, could that heart contusion have happened on March 20th and persisted all the way through April 2nd? Answer, no. Question, okay, we just saw a series of pictures of different injuries that you say Corey received. Can you say with any degree of medical certainty whether any of these injuries that he sustained was what caused the injury to the heart and the liver? Answer, none of the skin injuries, the contusions, can be correlated with what was seen internally. Question, okay. Now, you also said that initially you put your opinion that it occurred between 4 and 12 hours, right? Answer, yes. Question, okay. And then you changed your opinion based upon certain things that you were given afterwards, right? Answer, incorrect. Question, okay. Answer, I did not change my opinion. My opinion was amended or modified on the basis of new information. The basic opinion was still the same. The time frame was narrowed because of additional evidence that suggested that he couldn't have possibly have sustained those injuries prior to 9 o'clock. Question, so now when you met with Detective Mitchell and you met with Ms. Lento, did they discuss with you that if you put it between the 4 and 12-hour period, that he would have actually been in the care of his mother for some of that time? Answer, well, I knew that he did not get dropped off for custodial care to his father until 9 o'clock. So whether or not they mentioned it, I knew that that was the case. Question, so now you are stating that you saw a 33-second video of a child speaking to his mother. By the way, is that diagnostic or not diagnostic? Answer, it certainly aids in the diagnosis. It is not diagnostic in and of itself. However, a child is not going to respond in that fashion if he has already, or if he or she has already sustained those ultimately lethal injuries. Question, so in the 33-second video, do you recall it, by the way? Answer, I'm sorry. Question, do you recall it? Answer, the video. Question, yes. The answer, yes, sir, I do. Question, okay, do you recall that in the middle of the video you hear Corey moan? Answer, no, I don't recall that. Question, okay, do you recall in the middle of that video you hear Corey yawn? Answer, yawn. Question, yawn, like indicates. Answer, I don't recall that. Questions now, you also said that you saw a picture of Mr. Greger that we just saw on the couch with Corey. And you said at that point that he could have been asleep. By the way, is that picture diagnostic value or non-diagnostic value? Answer, it is of aid in reaching, it is not diagnostic in and of itself. It's consistent with the time frame that I think this injury pattern occurred. Question, so are you saying based on a 33-second video and a picture and ancillary things to show you when that picture was taken and when that audio recording was done, that changed your whole opinion on the 4 to 12 hours? Answer, no, it modulated or amended the opinion. These injuries were of fatal potential, and they could have been certainly responsible for a change in Corey's demeanor and behavior. Therefore, behaving normally at 9 o'clock precludes that portion of the original range of time. Therefore, the clock, if you will, must by necessity start at 9, but it certainly doesn't go beyond 1 o'clock. Question, so with that contusion to the heart that you showed us, by the way, I'm not a doctor, but let me show you what has been marked as states S58. I'm assuming that is the heart. Answer, you are on point. Question, thank you, doctor. Can I give you a Sharpie? Answer, sure. Question, can you circle the contusion? Answer, this is the, and there's some colloquy here. Bear with me. Question, how are you, doc? So that is the liver, right? Answer, this is the liver. Question, and that is the heart? Answer, this is the heart. Question, can you draw a circle with the marker where the laceration on the heart would be? Some more colloquy. Question, okay, how big was the laceration? Answer, it was described as, there's no scale on it. It was described by Dr. Ragasa as being 1.5 inches in length. Question, do you see it? Answer, yes, sir. Question, okay, is it about 1.5 inches in length? Answer, it certainly appears to be. Question, and about how long would a person live with a laceration of that size? Answer, it's not a matter of size. It's a matter of where it is and what it's doing. It's not going to cause blood loss because the heart is still intact, but it will disrupt the electrical activity of the heart, which can only be compensated for a limited period of time. In Corey's case, it was from the time he was injured until the time he was pronounced 5 o'clock p.m. It is not going to be the same for every individual. Some people would die sooner. Some people may die after a longer period of time. It would certainly not be instantaneous. Question, so in Corey's case, you are saying that he could have lived for 4 hours with an 1.5 inch laceration to his heart? Answer, given where it is and what it is, yes. Question, and are you saying that to a reasonable degree of medical certainty? Answer, I am. Then we have redirect examination by Ms. Lento. Question, doctor, are you aware that Dr. Larkin is an investigator with the medical examiner's office? Answer, I don't know who Dr. Larkin is. I know he's Question, you don't have any information that he's the actual ME? Answer, right. Question, okay, and it was actually a radiologist at Soch who did the postmortem CT scan? Answer, they read it, yes. Question, and why wouldn't you rely on a postmortem CT scan in regard to determining cause and manner of death? Answer, a postmortem CT scan has to be interpreted in the context in which it is taken. In this context, it was simply a reflection of Corey's having been deceased and did not aid in determining a cause or manner of death. Reliance on the CT scan to say he had pneumonia is utterly without scientific basis. Question, okay, all right. Question, now, do blunt force trauma injuries always leave bruising on the body? Answer, not always, and especially in the case of children who have fairly elastic qualities and plasticity to their skin. You can apply blunt impact injury over a broad enough area to transmit force inside the body and internally injure the body without leaving a contusion on the surface of the skin. That's not impossible. Question, and doctor, can you explain how that is possible? Answer, it is possible because of the quality or the characteristic of the skin, particularly in pediatrics. Now, in a person who is not 6, but 66, a different story. But pediatrics is unusual in that regard. Question, and does the force of the blunt force trauma have any impact? Answer, it depends on the magnitude or the strength of the force. Obviously, you know, a bump against an object is different than a blow that transmits enough force into the body to lacerate internal organs. So it depends on the magnitude of the force. Question, okay, did you make any findings or were there any significant findings regarding Corey's toxicology results? Answer, the only findings in Corey's toxicology results were medications that were given in conjunction with his attempted resuscitation. They gave him Naxalone, which is an opiate. We have an objection. Question, okay, can you tell the jurors who Dr. Falzone is? Answer, Dr. Andrew Falzone is the chief medical examiner, or was at the time, I expect he still is, chief medical examiner of the state of New Jersey. Question, and did he review this case? Answer, it is my understanding he did, yes. Question, and did he speak to Dr. Ragasa about that? Answer, that is what has been represented to me, yes. Question, and after that, did the Ocean County Medical Examiner's Office determine what the cause of death and the manner of death is homicide? Answer, that is my understanding. That's it.
Judge, there were 2 portions, I think, that were left out, like right after objections, if I could direct to the 2 sections.
Can I write down what
Page
you
and
just
line.
said? Go, say it again.
Is that okay, Your Honor?
But everybody needs to write down what you just said.
I'm sorry. There were 2 spots right after objections that I think there was some testimony that wasn't read.
Okay, can you tell me what pages?
Is that okay, Judge?
Do you want to do that sidebar?
Yes.
Sure, Judge.
Ladies and gentlemen, the court reporter, I thought did a great job of reading back because that was actually Rachel Chickalis, the court reporter that day. So she was reading from a transcript taken by another reporter. Once or twice at the area of a couple of the objections or sidebars, there might have been a couple words that were missed. I reviewed those with counsel, and I don't think that overall changes what the doctor testified to, and I think it would be inappropriate now to go back and read a word or two or three to you out of context. So I've ruled that the readback is satisfactory. Given the time, it's about 4:34. Do you want a couple minutes to talk, or you just want to say, want to recess for the day and come back tomorrow, or?
Yeah, I guess for a
Right,
minute.
do that, and then I'll get the key too, because I have to give you the key to lock up the evidence. So,
It won't be long though.
okay, all right, understood. So please resume your deliberations or discussions and let us know.
All right.
Yeah, I think we should just stay. Yeah, yeah.
Is right now, I just have a feeling they're going to be coming back out pretty quickly.
Yes, that's fine.
Judge, do you want to do this at some or go anywhere?
To what? For what?
I want to talk about that. Quick sidebar?
Sure. I'm going to have my inmates and other calendar matters reported 9:30 tomorrow. Otherwise I had a sentencing calendar on. I tried to cut it down. I adjourned some of the ones I could. So my plan would be to have the jury report at 9, get them in the jury room, and then try and handle some things out here. Any objections, I tell them I'll just be handling other things out here in general, and that, that's why they should knock, and it may take us a little longer to bring them in or anything like that.
That's fine.
All right. And then if there's a readback request or a long question or whatever, those people are just going to have to wait. So I tried to cut it down to about half of what it would normally be. Open the door and give the key to the foreperson and ask her to lock up the evidence, all their notes. Can you arrange that, Sergeant?
One officer.
Hopefully it's empty out there. Room. Hi, juror number 13, we figured we'd talk to you at sidebar about your scheduling issues.
Yes.
Notes and all the evidence in black cabinet.
Before you come out, all the notes and your binders and everything, all Sunday, just lock it up, bring the key out, and right.
Right? The 12 deliberating jurors have sent out a note, which we marked as Court Exhibit C20 in evidence. Quote, Dear Judge Ryan, we have had enough for today. We can recess. No verdict yet. Thank you, juror number 1, end quote. So counsel agree we can bring the jurors out and excuse them for the day?
Yes, Judge, thank you.
Very good. Jury out. And we need the 2 alternates?
They're coming.
Very good.
We'll just acknowledge everything.
Okay.
I'm going to hand you the key, Your Honor.
Thank you. I'm just going to wait for the alternates to come in.
It's okay. No worries.
So, ladies and gentlemen, thank you. A couple of announcements. Juror number 13, who was one of the 3 alternates, She advised us, we were able to speak to her at sidebar, that she has some personal obligations for tomorrow, and the timing of those changed, and she would have to leave early, so we've all agreed she could be excused. So we're down to 2 alternates, which should be just fine, obviously, since you've already commenced the deliberations. Got your note, we excuse you for today. Please stop your deliberations now. Continue to follow my instructions about no research, no outside contact or communication. Don't look up anything on the news media, and don't have anyone do that for you. To give you an update on what's going to happen tomorrow, you can be seated, folks. Thank you so much. Tomorrow, I already had a calendar scheduled of multiple matters that would come in, typically what we do on most Fridays. Because you're deliberating, I've tried to cut that down as much as I can. I'm going to have that calendar start at 9:30. So I ask you to come at 9. Hopefully get over here, get in the jury room, start your deliberations, and then you may hear us out here, or maybe I have people coming in and out or whatever. I'll try and get through those matters. That doesn't affect you, though. So if you have a question, you want to read back, you have any other issue, you just tell us, and then those people have to wait or get moved somewhere else or get postponed. So other than just giving you the courtesy of letting you know what's going on, I don't want it at all to affect your thinking, or I don't want you to say, oh, well, I can't ask for a readback because the judge is busy. That's absolutely not the case. You can ask for whatever you want. You're the priority. Just that some of those things I have to handle, but if I had to handle them at the end of the day, I would do that. Just telling you that. So it may take me an extra 5 or 10 minutes if you send a note out to get everything here cleaned up and get the courtroom empty and then be able to proceed with you. Madam foreperson, you've handed me the key back. Is the evidence in your notes locked up in the cabinet?
Yes, sir.
All right. So I acknowledge receipt of the key for the evidence cabinet from the foreperson, and I'll return it to you tomorrow. And that way we can have staff clean the jury room and without seeing any of your evidence. Anything else from counsel?
No, Judge, thank
No,
you.
thank you.
Thank you so much again. We'll see you tomorrow. At jury assembly, of course. It's 4:55. The jurors have left the courtroom. Anything from counsel?
No, Your Honor.
Thanks, everyone. We'll see you tomorrow.
Thank you, Judge. Yes. You're gonna take your laptop home, right?
Yeah.
Home, though. Ma'am, take it to, all right.